ठीक है, ಅರ್ಥ ಆಯ್ತಾ? T.S. Praveen Kumar. Nyayapati Prashant.
There are two writ petitions of year 2015. They have not been listed. I have filed vacant petitions. They must have not.
Which department?
Revenue.
Home law firm. Which department? 14%.
I have to withdraw the petition. It's regarding the memo matter J2 to 57 October.
You are the only petitioner or other petitioners are there?
I am only the petitioner.
So Arjun, B. Arjun.
The petition filed by action the responding authorities RTO in entertaining the appeal of
Ashok Kumar.
The matter pertains to challenging of work notification, but pleadings are finished contracts. Because of a final hearing, any date can be fixed in this matter.
Only two matters or there are other connected? A. Viresh Kumar.
I don't actually that is not following the orders given by the case for the partition of the law.
Akarapush. Shilu.
I have a response for not filing counter in the order instead of original.
What is the matter?
Original beneficiary illegal documents are staying under Bombay scheme. Government have taken land from the
Srinivas Rao. A. Keshav Reddy.
Petitioners have filed this suit for declaration.
Which district?
Coming for the defendants at that stage.
Which district? Which district?
Peddapalli district. And there is
21.
they have stays referred to Marwal.
So Power Counter Tom Kumar.
These two matters are also pertaining to land acquisition.
Yes, 24. So yes, K. Srinivas Prasad.
Page wise mention. Page 2, item 3 to 8. Page 3, item 9 to 24. Page 4, item 25 to 44. Page 5, item 45 to 53.
Item number 53, vacate stay petition, I8 work 2020 is pending, but it will be taken up at 30.
Be ready when the matter is called. Okay.
Please ballot item 27.
Yes.
This airport order was not yet ready, my lord. Because of the presiding officer and not well. We have this matter.
Yes, at request of Constable Petitioner, post after 4 weeks.
Page 6, item 54 to 62. Page 7, item 63 to 79. Page 8, item 80 to 92. Page 9, item 93 to 108.
Yes. What do you want? Yes, tomorrow evening. Tomorrow at motion.
Page 10, item 109 to 123.
Item 128, my lord. May not reach today, at least on Tuesday, my lord.
128.
Tuesday or Wednesday, any day, my lord.
Yes, you don't want tomorrow?
Tomorrow, my lord, Friday, it may not reach. So, Tuesday, last Tuesday.
Tuesday email. Yes.
Much of this, much of this.
item 130 kindly put tomorrow at 10 morning.
What is the matter?
Land acquisition without paying the passing award without paying comment.
Yes, yes. Tuesday. Yes, yes.
Page 12, item 140 to 154. Page 13, item 1.
243. But you kindly have it, but not soon. That's 230.
Why? 143.
240.
It's Tuesday.
230.
Tuesday. Yes.
Page 13, item 155 to 167.
Today. Yeah.
Tuesday adjourn motion list. Yes.
Page 14, item 168 to 184. Page 15, item 185 to 196. Page 16, item 197 to 209. Page 17, item 210 to 225. Page 18, item 226 to 242. Page 19, item 243 to 257. Page 20, item 258 to 276. Page 21, item 277 to 292. 292 minutes. Landing is maximum, readings completed, and the old people are there, 36 pieces are there, half a dozen old people are there. Request is 230 or Tuesday.
Yes. Tuesday, especially identified. Yes.
Page 22, item 293 to 303. Page 23, item 304 to 319.
The Lordship kindly, my lord, item 305, my lordship. This is the land acquisition matter, my lord, land is reviewed by the government, my lord, since last 2 months it is in the list, my lord. Kindly have it on your Tuesday, my lord. Already counter filed, my lord, in this, my lord. Reply also been filed. It takes only 10 minutes of your lordship time, my lord.
Yes, it's Tuesday.
Page 24, item 322, 326. Motion list, item 1, CH Ravi Kumar.
I take notice on behalf of respondents 3 and 4, request 1 week time for filing.
Regarding National Highway project, without hearing of objections, without disposing of passing order, AD was issued. Filed objections within time. In fact, district collector also filed objections because common integrate the collectorate complex is going. So he himself, collector himself, but those orders are also not disposed, those objections. DC is not adhered to the no hearing was conducted.
I get instructions, my lord,
Yes,
because
get
I did not
instructions.
issue the serial papers for.
Similar matter regarding status quo is granted.
What they referred in the writ affidavit, the writ petition number totally differs to criminal matters. What they have mentioned in the affidavit, there will be.
I filed a copy of the same adjacent village of same under.
So takes. Who is appearing for Kala?
I am appearing on behalf of respondent number 1, Union of India, on behalf of Senior Panel Counsel N. Bhujangarao. I take notice for respondent number 1.
Yes, GPR. Get instructions. Yes, Tuesday. See, so your understanding council takes notice for respondents 3 and 4. Standing council takes notice for respondent number 1. Notice for respondents. Post on Tuesday. Yes.
But because they are seeking stay of.
You are requisitioning authority.
Yes.
Yes. Please for the card. Land acquisition officer to answer.
Item 2,
I request for A.
Yes.
C. Jitendra Reddy.
Matter is Land Reforms Act, my lord, ceiling declaration of the 1976. Thereafter, my lord, for the purpose of the first petition, mother has been declared as surplus land. He has to surrender the land. But these and prices are murdered as early as in 1996. 92 murdered has submitted a report. See page number 41.
Yes.
Selecting certain items of land murder belong to the first petition mother is declarant for taking possession. That orders have been confirmed under section 10(4) of the Act murder by the Land Reform Tribunal. It is at page number 550.
Yes.
It's a case regarding surrender of land under subsection 3 of section 10 of the Land Reforms Act 1973, page number 50, my lord, I'm reading.
Yes.
In pursuance to the notice in Form 6, dated 19/1/1995, the declarant failed to surrender the surplus land. The Mandal Revenue Officer Shamil failed while selecting the following land that submitted the selection report on 12/12/1995 and also 25/1995. These are the lands which has been selected. The petition has no objection for selecting said land. Accordingly, general notice in Form 8 under Rule 4 of Rule 7 of the Rules 19 was issued on 1/2/1996 and got published on 6/2/1996. So and so filed an objection. I filed an objection petition on 13/2/1996 for selection of the land bearing survey number so and so of Udamari village. In their objection petition, they stated that they are in the position of the opposite survey number since last 30 years and got immediately in their name through ROR in the revenue. On basis of the record produced by the objection petitioners, it is proved that they have purchased the land through unregistered sale and some of them registered document of 1984, which are only after the notified date cannot be acceptable. Hence, their objections are hereby rejected and the land shown in the schedule being given below accepted for surrender and subsection 4 of section 10 is in accordance with the provisions of the Act is hereby approved under section 10 of the Act. These are the survey numbers which has been order has been passed by these are land reform tribunal. So far as the other lands are concerned, which are in the holdings of the petitioner, the particular passports have not been issued in favor of the first declarant matter because these proceedings have not been concluded. Then I approached the Honorable High Court by filing a petition matter directed to complete the proceedings with reference to my land. Court has directed. Now the present imperial order has been passed by the reviewing the orders of 1996 and selecting the other lands on the ground that these lands does not stand in the name of the declarant. If that finding is given, my lord, I become non-surplus land holder. Therefore, the other lands cannot be taken possession. Now you are also find with the present imperial order. After 27 years, my lord, this order has been passed. At page number 24, it starts.
No, those lands which are in possession of somebody else are to be included in your holding.
Yes.
There is no dispute about that.
There is no dispute about it. In the declaration form for it, I have shown these survey numbers which have been acquired, which have been selected in 1996 by the Land Reforms Tribunal. They were computed to my holding. The third parties have filed an objection before the
why is that?
Unless there is a clear sale deed, my lord.
Authorities are entitled to take possession of the undisputed land.
Yes.
And,
after 1996, it was undisputed only.
No, somebody else are in possession.
No, Your Honor, that has been accepted in 1996. Your Honor, can you take note once again for the purpose of clarity, page number 50. Land Reforms Tribunal has passed an order in 1996. Page number 51. On perusal of records produced by the objection petition, it is proved that they have purchased the land through unregistered sales and some of them unregistered documents, which are only after the notified date cannot be acceptable. Hence, their objections are hereby rejected and the land shown in the schedule given below are accepted for surrender. Once they have been accepted by law, if any person agreed by the same has to prefer an appeal before the appellate authority. Yes. And there is a power to the Land Reforms Tribunal to review the order that has been passed finalized in 1996 in the year 2023.
Yes.
There is one direct decision by lord of this on the court matter you must kindly consider.
Yes, that is good. As far as I know, so far, so long as that surrender is concluded,
yes,
and it is always open for them to seek surrender of alternative land.
It's true, but once the finding that has been given is
you ensure that that land is surrendered to them.
It is for as in 1996 they have
you have sold
for the same.
You have sold the land after the notified date.
No, it's not.
That is what is the finding.
Declarant is here that long back.
No, declarant only sold it after the notified date.
But that has been negated by the authority.
That is accepted.
For the objection petition, see something else, whether they have to file a suit for damages against the declarant or the legal helps. But authorities cannot, my lord, change the other land
Yes. What is this citation?
Yes, once the land has been completed when notified. The head note itself has a land reform ceiling and agricultural land section 10. Surrender of excess land. Rejection of land offered by the declined by land reform tribunal without informing him the nature of objections and without giving an opportunity to explain it, without daring to follow the directive issued by land reform separate tribunal in appeals by reminding the matter several times. Amounts to careless and indifference exhibited by land reform tribunal in dealing with the such proceedings and valuable rights of the declarant. Any property included in the holding of the declarant must be acceptable in surrender proceedings also. If any items of the property offered to surrender are not acceptable, such items be excluded from the holding of the declarant. Correspondingly, excess land shall get reduced. Orders of land reform tribunal and land reform separate tribunal rejecting the items of the land surrendered set aside. Direction given to land reform tribunal to accept the items of property offered by petitioner declarant following the aforesaid findings. In the instant case, my lord, as early as 1996, the land reform tribunal accepted the surrender.
Yes.
Now, after 27 years, they say that if some third parties are in possession, they cannot sell it to alternative land. Now I become virtually a landed poor person.
No, because you have exhausted your land after you sold it after the notified date in violation of the law.
Their objections were rejected. Once that has been computed in my favor, they are bound to take it. They have to issue notices to them and to give it.
They are entitled to take land which is not under dispute.
That is when, after 27 years of the finalization of the proceedings.
Because proceedings are not concluded.
The order that has been passed in land reform tribunal now, my lord, has set aside the orders of 1996 as well as the orders of 2008, my lord. Unfortunately, that orders have not been filed. Lord, may kindly correct. This is the order where the third party objectors have filed an appeal before the authority with regard to their claim that has been rejected by the land reform tribunal.
It's on your application. You made an application that was considered and ultimately this order was passed. It's not their sumoto they did something.
Yeah, they have not finalized with regard to my lands. That's the reason why I have approached the Shamla Court. I have made several representations to them. Since you have accepted and finalized the 1996 proceedings, please finalize the proceedings. You will not kindly take this 2008 proceedings. You will not kindly take the 2008 proceedings. Page number 30 of the impugned order. Page number 30, impugned order.
Yes.
The first, the report of the title, what it was.
Yes.
The report of the title commander clarifies the entire issue and the said report speaks for itself and is the big case for invoking the provisions contained under the 9A of the Land Reforms Act 1973 and under Rule 16(5)B of the rules for modifying the award dated 26/5/2008 and consequently rectifying the earlier order dated 22/2/1996 for saving precious government land. Failing the beneficial provisions of the Act itself would be defeated and frustrated. Now you can take the 2008 order award which has been modified now. This is an appeal filed by third parties. Now order minus last button page. As per the direction of land reform separate tribunal, notices have been issued to both declarant and also appellants to put forth their evidence in support of their claim. But none of the appellants have submitted the documentary evidence that they have purchased the land as per their claim before the land reform separate tribunal prior to the commencement of the Act 1973. Hence, the claim of the appellant in LRA number so and so are hereby rejected and the order passed by land reform tribunal on 22/2/1996 is hereby confirmed. Once this order has been confirmed in as early as in 2008, now madam, this order has been settled by land reform tribunal once again. Where is the power of review? I have not played any fraud. Section 9A, my lord, gives the power to reopen the declarations, my lord, only when there is a case of fraud. Lord may kindly consider, my lord, 9A of the Act.
Yes. Yes.
May pass on it.
That's the amended provision.
Yes, sir. 9A.
Yes,
Reopening of cases by the tribunal.
yes.
Notwithstanding anything repugnant to the provisions of this Act in respect of cases where it is found that orders were passed due to any fraud or misrepresentation or suppression of facts, and where no subsequent orders were passed in appeal or revision on the same, the tribunal may either suo motu or on application or the direction of the collector or chief commissioner of land administration or government reopen such cases and pass orders afresh, as if no declaration has been filed under Section 8 of the Act. Now, this Section 9A has been invoked by the Land Reform Tribunal in the present case. Only 3 contingencies where there is a fraud, misrepresentation, and suppression of fact. I have not suppressed anything, I have not misrepresented, I have not played fraud. Everything was recorded matter earlier also. The third parties have filed their objections before the Land Reform Tribunal, that was rejected. They preferred an appeal was rejected, that orders have become final. No, my lord, they are again reopened. For reopening, my lord, there is no power under Section 9A. Lord, sir, kindly for the purpose of clarity, where no subsequent orders were passed in appeal or revision. An order has been passed as early in 2008. Only when there is a power of reopen, my lord, where there is a fraud, then the applicability of Rule 16(5) would come into operation.
It's not the question of exercising power. That surrender has to be concluded. Surrender has to take place.
Yes.
Whatever surplus land is declared as surplus,
Now, once
that has to be surrendered.
Yes.
And till that surrender is concluded, and proceedings are not concluded, unless that surrender is complete, the question of declaration becoming final does not arise.
Once they have accepted, my lord, that certain lands are committed into my holding, my lord, they are bound to take it my respectful submission. The objection filed by third parties have been rejected by the authorities, by the Land Reform Tribunal, and also by the Land Reform Appellate Tribunal. Now, by virtue of this order, my lord, by the impugned order, the authority, my lord, is favoring the third party objectors who lost their case before the Land Reform Tribunal and also before the appellate authority.
Authorities are nothing to do with the disputed lands. That is.
No, you have to kindly consider. Once that land is not standing in my name, my lord, I have no objection to delete from my holding itself.
See, you sold it after the notified date, and you can't have any objection for deleting, and that is bound to be included in your holding.
Once that has been included in my holding, my lord, it is for the objectors, my lord, who have purchased the remedies elsewhere.
No, the remedy elsewhere they may claim against you, but so far authority is concerned.
And result is, my lord, authority is favoring a candidate who have lost their case before Land Reform Tribunal and also appellate tribunal. Now, virtually, my lord, by virtue of this order, I become a landless poor person. Where I have been holding
Because you sold the land.
I have even 1 acre of land.
Obviously, because you sold the land after the notified date.
That has been once that has been computed in. That is the reason why I find a copy of the settlement.
Judgment of Justice Narasimha Reddy is totally on different footing. And
once that has been accepted, my lord, computed into my holding, my lord, they are bound to take it in by the proposed submission.
no, are they not entitled to say take possession of the undisputed land from your holding? Towards
Where is a question of dispute, my lord? The dispute, my lord, they have raised a dispute before Land Reform Tribunal. The third party is claiming that they are in possession. That claim is rejected. Then they have preferred an appeal. Appeal is rejected.
Still,
Once that is rejected, my lord, they cannot claim, my lord, they cannot claim the right over the land.
it is your duty to see that the position of the surplus land is delivered to them.
Once 1996, when they have taken possession, it was vacant. Now, subsequently, somebody has occupied, my lord, I am not to be held responsible for the same. As they said in 1996. Never there was an objection by the Land Reform Tribunal or by the Tahsildar who has submitted the report. And that is on the part of the authorities, my lord, right from 1996, I have been making representation to them. Ultimately, I have to approach this Honorable High Court in the year 2009. Now, after 14 years, my lord, they have come up with this order. The urban area, your lordship knows, my dear, even difficult to hold a property of 100 square yards. Now with 117 acres of land has been taken over by the government now, virtually making me a landless poor person. The beneficial legislation not only to the government but also to the landholders.
How it is beneficial legislation to landholder?
That's the reason, my lord, because
Huh?
what at least one ceiling unit, my lord.
Because you sold that will be computed in your holding.
That has been computed.
Yes, what do you say?
Objection filed by third parties have been rejected. Rather today I am in possession of the land.
That does not give you any advantage to you. The higher objection being rejected won't give any advantage to you. Your obligation to surrender the surplus land.
The date of the selection of the land. With the sewer motor, they themselves have selected, but not surrendered it. Lords may kindly take on 1990. The prices there, in the 10-3, my lord, he himself has identified the land.
Yes, yes. What do you say? What is the stage now?
The order has been passed, my lord. The order copy has been communicated only recently to me. I am in possession.
Yes. Get instructions Tuesday.
Meanwhile, my lord, if they pass an order, my lord.
No, the law otherwise. Law is otherwise. That's what I remember.
Let that be started with regard to possession at least. Let there be a suspension, my lord, 1 month. Not a suspension for a limited period.
What is the paper admission? Pardon?
Consider nature of the
Second respondent pass the order now. Yes. You are taking notice, right? Yes. And AGP for revenue tax notice for respondents 1, 2, 1, 2, 4. File your counter. I will pass imprimatur for limited period. Status quo, I'll pass status quo and you.
That means otherwise I would have come long back.
Because you are expressing your difficulty and to the.
Let there be a suspension, will not create any third party interest. Not a meeting the conditional order.
1812. Status quo in all respects to be maintained by both the parties. Status quo by both parties. Please. Status quo in all respects by both parties. I said.
Item 3, 4, and 5.
Yes.
I will explain the actual matrix.
You are appearing for
Petitioners.
You are here. Why name to be printed? Yes.
Gates and defense.
It's good. 2002 matter. What is this? Yes.
The petitions for lordship in the batch of petition. Changes its lands not in the year February and March 2000. The restart sale is not in the layout.
What is the relief in the restriction?
They are challenging the notification and declaration, and it reminds that both are issued on the same day. It will be a question of law. All the petitions are allowed. I will agreed with the notification and declaration which have been issued. Same day, the Jagannath law. Also, if the sitting proportion of your wage affects to the notification for another channel.
Game prayer and over.
Let us say 4-1 notification, it is shown so. And 6 declaration, it is shown so. In form for any property may be very external. Issued by the fourth respondent, and direct the respondent further drop the land acquisition proceedings, further directing the respondent not to interfere. Payment for the houses, plots, very good plots. So you see, please start by the beginning.
Why so many petitioners?
There are 120 plots.
No, you are seeking relief only in respect of petitioner number 1, 6, 8 only.
There are three petitions. 2.795.
And the first rate petition law, you are questioning only in respect of plot number 53, plot number 83, and plot number 48.
20396. There are 23 petitions.
Avunandi, how many plots?
Plots are given in an annex.
Prayer line ఉన్నాయండి plots.
They did not mention plot numbers.
చూడండి సార్ మేము ప్లేయర్ అమెండ్ చేశారు.
My lord, subject to lordship's pleasure, my lord.
Yes.
And my lord, this is Samsa Pratap, my lord, appearing for B. Venugopal, senior advocate.
Yes.
My lord, in this matter, he is appearing for the R18, my lord, the society, which is the beneficiary.
Yes.
My lord, this is a land acquisition matter where, my lord, it went up to the Supreme Court, and Supreme Court also confirmed the notification. And also, my lord, on their request, my lord, the petitioner's request, it has been, they requested for other, my lord, the reliefs they claim with regard to the enhancement of the compensation. Now, my lord, the Supreme Court judgment is there, my lord, there. My lord, I'll submit all those judgments, and also, my lord, if your lordship so pleases, this may be taken up on 14. My lord, item 3, 4, and 5, my lord, go together. Now, with regard to the, now, my lord, there is a, it has been allotted in 1990 itself to the employees of the Telangana state, my lord, and constructions have been completed and they are living there.
Come in the whole matter, sir.
That's the reason, my lord.
No, it's listed on your slip is moved, my mention is made and the matter is got it listed.
My lord, I am appearing for the respondent society, my lord, because I have to place all these judgments.
Not for respondent. Who is for petitioner?
I am for.
You are opposing relief case of the petitioners?
Yes, my lord, I am opposing the relief, my lord, because they already made constructions and they're there in the entire, it's a my lord, completely constructed layout. It is allotted to the employees, my lord, in 1990 itself, the plots. They're asking only for the compensation. Now, my lord, it's the second round of litigation, my lord, the petitioners now before your lordships.
Are they not entitled to compensation also?
Yes, my lord, they are asking for the enhancement of compensation.
Therefore,
All these, my lord, subject to, my lord, I'm representing only Mr. Venugopal Rao, senior counsel. My lord, he's on legs.
They are asking for compensation. What is your objection?
My lord, so far as the enhancement of compensation is concerned, my lord, I can't have any objection. My lord, if they want the, my lord,
For enhancement of compensation.
yes, ma'am.
Then if that is the case, what is your role in this?
Yes, my lord, my role won't be there if it is enhancement of compensation. But the thing is, if they want the land back to them, questioning the notification, my lord, certainly my role will be there because I'm the affected party.
It is by operation of law, because this is not a second round of litigation. This is the earlier batch of litigations filed way back in the year 2002. Telling the notification.
Yes, who is appearing? You are appearing.
Telling the notification and declaration. I will explain the factual matrix, undisputed facts, my lord. All the petitions herein before lordship. In these petitions purchased nearly 106 plots of developed plots, my lord, in the year 2000 under a registered sale lease. The notification has been issued on 8/6/2001, my lord, in Form 2A, acquiring the land belonging to the petitioners, that is admeasuring 6 acres 23 guntas. This is a layout plotted, purchased by the petitioners way back in the year 2002. My lord. Against law, my lord, on 8/6/2001 itself, the declaration under section 4.1 as sorry, my lord, notification on section 4.1 as well as declaration under section 6 has been issued on the same day, which is against the law settled by the Supreme Court.
Why if urgency clause invoked, they can't do it?
Even urgency clause being invoked, it is a settled law that they cannot dispense with the procedure. Publication of the notification. Publication of the notification on section 4.1, my lord, it can need to be followed. Even urgency clause has been imposed, I will satisfy all said not. This is only a question of law. So declaration and notification issued on the same day. Subsequently, not the publication, because they did not dispense with the procedure. They have followed the procedure. On 8/6/2001, draft declaration form issued on 24/7/2001, publication Form 2A in the pledged English paper. So the publication as mandated on section 4 has been followed by the official respondents regarding the notification. So there is no point in canvassing that they have been dispensed with. This notification has been issued in the 2 newspapers, my lord. the concluding portion, my lord, the substance of the draft notification and draft declaration was got published in the locality, including these are the undisputed facts borne out by record from the counters filed by the official respondents, my lord, on 8/10/2001. This is the final date of publication of declaration. Yes, as per the affidavit submitted by the official respondents, my lord, the award was passed on 31/1/2001. Your Lordship may kindly see, initially, the landholders filed three writ petitions. In three writ petitions, my lord, 20396, 22046, 25795 of 2000. All these writ petitions were filed way back in the year 2002, my lord, and an interim order passed by this honorable court in their favor. Subsequently, my lord, what my land friend is saying, on 9/10/2003, subsequently, after notification, after passing an award, because notification, my lord, your lordship may kindly see, these lands were acquired for the purpose of cyber park. It was there in the notification, it was there in the declaration. Subsequently, in the year 2003, my lord, this land has been allotted. Some other government land also allotted, including this land, to NGOs by virtue of 1033 dated 9/10/2003, my lord. For NGOs for housing purpose. The cyber park had gone. Having agreed with this, my lord, the petitioners herein also filed a writ petition challenging this GO, petition number 17228 of 2008. My lord. It was
No, very same notifications were upheld by the Supreme Court.
Yes, my lord.
there are
And when it came up subject to correction, my lord.
I'm saying,
I'm not asking you, sir.
sir, nothing has been concealed here. Everything I am bringing to the notice of this honorable court, my lord. There are three writ petitions, my lord. 20396, 22046,
Sir, I have gone through your note. You don't have to repeat all that now.
So one of the writ petitions was dismissed by this honorable court.
Yes.
Against that, writ appeal was prepared, writ appeal dismissed, against that, SLP was prepared. There is a stay for 6 years, my lord. Subsequently, in the light of the introduction of Land Acquisition Act 2013, because it is the case of the petitions that they did not pay the compensation before the lower court, my lord. Because as per the latest Act 2013 Land Acquisition Act, even after 5 years, if the question is not taken or the amount is not being paid to the petitioners, it will lapse. On the premise that the petition was dismissed. Then they have got alternative remedy under the Act 2013. Curiously, my lord, the same notification and declaration for the adjacent lands were allowed by this honorable court in the year 2002 itself. It was not brought to the notice of this honorable court by disposing this application. It was not brought to the notice of this honorable court. The pendency of the other two petitions now, your lordship is adjudicated. Only one of the petitions was dismissed. The matter went up.
Where is that order of the Supreme Court? Compensation was not even deposited.
Not deposited before the court. Very sad.
Yes.
I further bring to your kind intelligence, my lord. Before the Supreme Court, my lord, when this matter is being adjudicated, the state of Andhra Pradesh, intimated to the Honorable Supreme Court, because there are 5 petitioners in the said petition, in the SLP, only 5 plots. The government of Andhra Pradesh indicated, I will supplement the others passed to the Supreme Court. Government of Andhra Pradesh indicated to the Supreme Court, while the order is being pronounced, the government of Andhra Pradesh indicated that they will provide alternative plots. to the
Where is that?
settlement. It is in the form of an order settlement.
When? Very yes.
One more repetition is not listed, even though it is.
Don't tell all that. Who moved the slip?
I moved.
Then why are you not ready? Then why do you say why don't you produce that order of the Supreme Court?
Yes,
Supplement means when will you supplement?
tomorrow itself.
Why not today? When you moved a slip, why are you not ready?
I am ready. Just some crossover.
Who is appearing for state?
Moreover, I have compiled all the PDs in on volume along back at it is not there.
It is there for Supreme Court order is there in that?
Supreme Court appeal. At that time, Supreme Court order was. There are 3 orders of the Supreme Court.
Place on record tomorrow. Who is appearing for government? Standing counsel? Required for the benefit of HMDA originally or?
Originally for cyber park.
Yes, I see.
The land was has been exposed. The notification is there.
TSHC was made requisition. Subsequently, it was exchanged to a housing society.
Who is the concerned respondent, sir?
What?
You don't have any papers?
What? What was it?
You are appearing for R6. You are appearing for? Now you,
Right, the farmer.
no, it seems the land is already taken possession and constructions have already come up. And what is the relief that you expect now?
Alternative process. English question of land.
Where is that order of the Supreme Court? You don't have copy also. Where you say that the government has offered
Alternative process to those petitioners.
where is that order? You don't have copy also with you. Next to the one. You are appearing in the item 4 also.
For us. Five. I am along with the Hariharan.
5 also you are appearing.
Hariharan along with. I will place the entire pleadings in one volume. Already very good. It's easy for a lot.
Where is the judgment of the, you said 4 and 6 can't be published on the same day?
Yes, sir. (1989) 1 HCC 590.
You have copy?
I will get that finding, so.
Give it. Is the same law is holding now? No, do.
So far, that is, it is concerned, same law is holding land. Basing upon the law, taken by the Honorable Supreme Court, this Honorable Court allowed a writ petition relating to the adjacent lands which were issued on the same day.
What happened to that acquisition?
It was lapsed.
No fresh acquisition.
I don't know, the people, I was informed that it was lapsed. Adjacent lands are the
Where
same.
is that order in the other? Where is the order in the other?
Line లో ఉన్నారు.
I already filed in the history.
There is more subsequent purchases. The petitioners are subsequent purchases of the notification. They can't submit the notification. They are only entitled for.
Petitioners purchased after the notification.
Before not 2000. These persons purchased this parts in the year 2000. All the sales lists are part of the record. Notification was issued on 8/6/2001. Only on the premise initially the mark was passed. By the date of notification, the registered sale deeds were executed in their term. All the series were immediately described in the affidavit manner, and they are part of the record.
Most of them are prior to the notification, one or two. Most of them are prior. March 2001 notification in June 2001.
June 8/6/2001 is the data.
If on that legal issue, that both the notifications cannot be published on the same day, and 6 is bound to be declared published
6 go.
after the date of whatever notification, then award has to go. If award goes, then exam that also. What should follow?
New under the new act,
They have to initiate new under new act. As we may not direct restoration of the land. You are insisting for.
We are insisting for alternative lands as also by state of state of the. I will supplement tomorrow itself.
Then we
Solve the
also look into what should follow also consequences so that we can dispose of tomorrow.
Yes, my lord, I'll place it, my lord, on 14th, your lordship so pleases.
Yes.
14th may be taken, my lord, I'll place all these record and also, my lord, the judgments of the Honorable Supreme Court.
What is your concern? You tell me.
My concern is, my lord, if notification goes ultimately, my lord, he may ask for the restoration of the land.
They are not asking for restoration of land. What is your objection?
My lord, so far as, my lord, he has to place, my lord, he is referring to the orders passed and notifications of other land which is not concerned.
They are not insisting for restoration of land. What is your concern? What is your objection?
Anyway, my lord, I'm only requesting for 14th of this month so that I can place the, my lord, Supreme Court judgment and also argue physically present and argue the matter.
Request of third council for petitioner post tomorrow. Tomorrow. Yes.
6 to 11, item 6 to 11. Amin Narasimha Reddy.
Yes.
Item 12. Here will Reddy.
Yes.
So that's part of the petition. Partition. Frequently there was a partition between petitioner and each other. They were granted. There are part but the elder one, they get sold the property after the property. Well, assuming that they also received this petition. Then about this petition and file appeal, it was not considered an aspect. That order is equal. First follow one opportunity question. So no notice to this petition and it's you not because you not solved.
Let's see the order.
It's 12.
Tahsildar order. Let's see Tahsildar, sir.
Yes. 680.
Page 20. Yes.
Now they put in the name very far. Yeah, and answer it a good but not leading. Yes, also expecting Suresh is the Maroon condition. If the wish is not serve the orders and requested to pass revise the orders. Even the the cost. The cost considered. Here we order to decide that to extend. From the in-laws of your in-laws of signing, eight Balaya and in-laws of Shankar purchase. Typically, no notice the served for the beginning. They passed away, the sons were not served. Suresh was not served. But that admittedly, Suresh was given particular passed for that 20 mundas. Kindly see on page 22.
So what do you say about the allegation that 4 acres was sold to Venugopal and 1 acre 10 gunta to Prabhavati?
But there I have to submit. But it is uncle, he cannot say because word of partition between them. Subsequent partition is also there, and this partition was given book also.
Both of them sold in the same year.
But Shankaraya, of instant older, his father, had never sold. His uncle sold. Correct? Otherwise, kindly see about the book and page on 22, your kind. The book is should be petition. Kindly see the page.
No, how can brother will get in respect of an share in the assigned land?
The petitioner's grandfather was in fact assigned the land. Otherwise, he could not have got this.
No, the assigned lands are heritable, but not so. See page 19, top paragraph. Balaya, who is the Lavani Patadar, has sold land 3 acres to so and so through registered deed, and his brothers Shankaraya and his sons have sold 1 acre 10 gunta.
When I did look on page, the penultimate para, through the fifth reference item, the Panchayat Secretary Nizam Division has reported as the original assignee, Balaya, as extra leaving behind his sons.
That is subsequent to 89.
But in fact, was the assignee
No,
Balaya.
89 he sold it through registered sale deed.
Whether, in fact, assignee is Balaya. According to that. But repeatedly, well, this petitioner
Yes,
is.
Balaya sold 3 acres in 1989.
Can you see about I get sold. Shankaraya also expect living behind his son's name, his brother. So and so. Due to which he could not serve the orders and requested to pass revised orders.
That's all right. No, Shankaraya and Balaya also sold.
Balaya is not supposed to sell. He is not authorized to sell the entire extent. Because
He is the assignee. Who is the assignee?
the assignee is Shankaraya and Balaya's father. In fact,
కాదు కాదు. Lavani Patta in the name of Balaya.
but he being the eldest son, his name recorded. And it was partitioned also. But otherwise,
There is a question of partition of assigned land.
after once it records the family followed they themselves. Otherwise, he could not have got this book also. Book was issued by them.
Yes.
But my request is about was not served with the notice that the authorities may consider it and was appropriate. That's all.
Because you already sold it. Where is the question of notice to?
Petitioner or his father.
Petitioner's father sold.
Your Lordship, can you see? After ballot partition, he cannot sell his marriage. And apart from that, your Lordship may see, Lavani rules follow. There is no prohibition, on the Bharat is not applicable to this land, which was assigned prior to 56.
What are the additional documents filed? You have filed 2004 Pahani.
In 1991 is right. Two brothers left also.
No, by 2004, who was in position?
2004 Lord left. The petitioner's is Lord issued. The petitioner is shown to be in possession by issuing this book, 21 Guptas.
Counter filed.
Page 20 of the
It was,
the year 2004 had been resumed back to the government.
Page number.
Okay, page 20.
అదే కదండి దాని మీద కదా రిట్ పిటిషన్ వేస్తుంది ఇప్పుడు. What RDO says on the note issue of notice?
repeat order is passed. See no reason to interpret the order of the law.
Collector.
Collector is on page 14. So the joint collector notice is just beyond the notice.
Issued the assignees and purchasers.
Pardon?
Say assignee.
Page 18. Para 2. Page 8. Therefore, notices under Code 3 of AB assigned as and shall be have been issued. Legal issues the assignee and purchasers of the land paying service. Response to the said notice, but Angeta Veni Gopal, the Pasmavati have submitted application about.
They have not come before this court. Purchasers have not come before this court.
No,
They did not question.
no. Only disagreement is in question of the property around 21 Gunta. All along he is testing that no notice was certain. That was.
They say that assignees of legal rights.
The Lord's mechanism to PS the bar. Through village security, they say that none of them are issued. It is not admitted to saying that so issued. No. To which address and all that is also not stated. In fact, no, this is not amenable to Quota Act also. It is
Petitioner's father. The Pasmavati. Registered there.
Then what do you say? Page 21, last but one paragraph.
Page 19.
Page 21, last but one paragraph, last two lines. Due to which could not serve the orders and requested to pass revised orders. What is that?
Now the order side was guys.
I'll post it tomorrow. You get instructions what happened to the whether other petitioners, others purchasers have filed any writ petition or not,
Yes.
and what is the physical status of the physical condition of the land. Remaining extent,
that
you also get instructions. Okay.
to previous order.
Yes.
So then
So, let's see here on the written. No counter of the is filed. However, AGP for assignment. We can both but council are directed to get instructions as to the physical condition of the subject property as on date and also as to whether the purchasers of the assigned land have filed any petitions. Especially in the impugned order is petition, the resumption. Post tomorrow permission. Get instructions, but don't ask time tomorrow.
Item 13, B Rachna.
It is represented by so and so, representing 11.6 of the petition. Matter is settled out of court.
Yes.
Out of court, and seeks permission of the state without it. Yes.
Item 14, B Shivkumar.
For the unofficial record and important. Kindly possible to that.
Coming for counter.
Yes, first.
The password is made tomorrow.
Yes, tomorrow.
Item 15. Rajana Kapoor.
Yes, Mr. Kalyan. Yes.
Business assigned lands for technical purpose. Special crossing.
No, by ordering this amendment, it can be adjudicated based on the same pleading.
The counter is completely based on the same.
No. But it is.
I admit that it is mistake. Your losses funded me, I think. Extra.
Additional counter, if any, consequent upon amendment, respondent shall file their additional counter, if any, within a period of 2 weeks. They are pursuing that proceeding, which is filed along with the counter. If you want to file an additional counter, you file it. Like, make correction in the IA. And also, what is this index also? Read from the caption.
Item 16 to 19. B Sitaram Organi.
You said it is covered.
It is covered by a judgment rendered in 2024. In the online, page 118, I'll just pass on the copy to your office.
Yes.
I'm appearing for the work board Millard in this matter.
There are two sets of restrictions before you, two sets of cases before your office. One set purely concerns the work board. Another set intercept between the landlords and the persons who were given ownership certificate under 38. The work tribunal, my land friend is appearing, this case covered throughout the dispute between work and the party. I'm not sure whether my land friend has gone through the judgment. Who? My land friend.
Yes, Mr. Joshi.
Millards, there are three writ petitions and 2 revisions before my lords.
Yes.
Millard, item 16, Millard, I appear for respond number 2. Item 19, Millard, I appear for respond number 3 and 4. And my lord, item 18, I am the sole respondent.
Yes.
Now, my lord, before my lords, my lord, parties have set up, my lord, 3 theories. My lord, the petitioners items.
Senior counsel says it is covered by an order passed by division bench of this court.
Alright, my lord, that judgment, my lord, survives. But my lord, if I may submit, my lord, with due respects, differ, my lord, with the applicability of that judgment, my lord, to the present circumstances. May I make a submission, my lord, in that context?
Then let me hear the counsel first.
Yes, my lord.
Lord, if your lordship kindly takes Lord WP 2029 of 2000. 21889 of 2020. They both go together.
WP number?
WP number 20293 of 2000.
Yes.
And Lord, WP number 21889 of 2020.
Yes.
They go together.
Yes.
Lord, WP number 20293 were filed by the vendors of the petitioners in WP number 21889 for the same relief. That is challenging the notification issued under the Work Act.
Yes.
Therefore, these two go together in my humble submission. Then, my lord, there is a CRP number 1127 of 2012.
Yes.
My lord, the original Patera challenges the gazette notification in a OA before the tribunal. Tribunal dismissed his case. He filed CRP. So, all the 3 cases, my lord, the gazette notification is said to be on the charge.
Properties are different.
No, same property. Same property. Same property. Same property.
Same properties, my lord.
Yes.
CRP covers my lord around 113 acres. My lord, these 2 restrictions cover around 40 acres. 30 acres.
So, but you need a interstate dispute between the.
No, there is present as against the work tribunal, we say it together.
Yes.
Sorry, work
Board.
board, we say it together. My lord, there may be disputes between the landlord and the tenant. Those 4 CRPs are separately there.
Yes.
We will come to that at a later stage.
Yes.
Now, my lord, in the restriction, video lordships kindly take to my lord 2029. By engaged Seniors and senior counsel these matters. Lakshmi ideas and bundle so that's why assist
Building చూద్దాం covered అని అంటున్నారు కదా. So you are sailing with him.
Questioning the notification.
Anyway, both dispute between both of you cannot be decided by this court.
I find the method attached to this.
Oh, we'll deal with this gazette notification issue and the other will delete it. Yes.
Lord, may I just come to my lord? The prayer portion is the one thing because what I mean, the challenge have sold the property to the third parties. So third parties are presenting the by posting the.
Sir, dispute between you that CRP, that CRP is again also against work tribunal order.
One CRP comes against the.
Yes, my lord.
Other one against joint collector order.
Joint collector order.
That will delete. How that is connected to this?
Yesterday he gave that number saying that this is part of this batch.
That will delete.
That's the main thing. It covers the entire land, 32 acres also it covers.
That's a dispute in both of you.
Original tenants are the parties, they are not the
tenants. There also gazette notifications under challenge.
No, no. Only
That's me.
these 3 cases.
That's may I clarify?
Can I just submit it?
Yes.
My lords, the total extent of land measuring 130.
2011 matter and yesterday matter came up. You should make some arrangement and as and when matter is listed, adjournment is sought.
Monday finally.
Aim final end Monday.
Regarding that judgment aspect is concerned, only my lord, one submission is there. Rest I leave it to my lords.
Yes,
that judgment, my lord, I don't dispute. That stands, my lord. But
yes,
for my lord, limited aspect, whether the judgment can be applied to my lord, the present case is the only question, my lord, I am my lord, expressing
yes, that will
submission.
exam. Yes,
That is the only submission, Lord. That's
Let's,
not the
my
only.
lord, this matter, my lords may please to appreciate, my lord, the comprehensive judgment, my lord, passed by his lordship's, my lord, Chandar, my lord, is relied upon the judgment passed by Sri Ramchandra Rao Garu, Justice Ramchandra Rao Garu. That is derived, my lord, from, that is placed, reliance is placed on 1979 judgment. My lord, in 1979 judgment, by that time, my lord, 1954 Act was in force. My lord, in 1954 Act under Section 6 of the said Act, my lord, third parties to the works were not granted rights to, my lord, challenge the notifications. Basing on that aspect, that third parties, my lord, notifications was not binding. My lord, a right came to be, my lord, poured in the third parties to challenge the notifications by way of writ petitions. But subsequently, that principle was not considered. 2013, Section 6 of the Act was amended. 1995 Act came into force. Section 6 was amended, and all parties, aggrieved from the Gazette were granted, opportunity to challenge said notifications before, the tribunal. So, judgment, the principle drawn from out of 1976 judgment, insofar as to a right created in a third party to challenge the Gazette notifications under 226 only will have to be considered by my lords. No.
I'll show to your lordship that judgment. Can I just?
no, it's not that in all matters they should go before the work tribunal.
I understand that. But
Notification-
because they are placing reliance on this judgment, I'm compelled to make this submission.
Yes.
Can I just?
But in cases, if I may say so,
సార్ ఆయన ఇవ్వనివ్వండి విననివ్వండి తర్వాత వింటాను.
సరే క్షమించండి.
Can I just take your lordship to the prayer Lord in the writ petition 20293?
Yes.
Lord, certiorari what notification published as serial number 30908 in supplement to part 2 of the Andhra Pradesh Gazette number 36 dated September 4, 2003 in respect of the lands measuring 3226 Guntas in survey number so and so. But we are only claiming 626, 638, 639 and 640.
No, there is no such extent mentioned in the prayer.
Your prayer 32 to 26 Guntas.
20293.
Yes, sir.
Only mention serial number 30908, part of supplement so and so. No extent, nothing.
In 21889 extent is mentioned.
In the affidavit it is mentioned, but in the writ petition it is not there.
No, in prayer in WP 21889,
Extent is mentioned.
that extent they mentioned.
Yes, yes.
But ultimately, the challenge is to Gazette notification number 36A dated September 4, 2020. But the grounds for challenge mentioned in paragraph 8.
Yes.
Can I read?
Yes,
I
yes.
respectfully submit that to our staff and supplies we learned from the office of the Commissioner Farooq Khan that respondents one in his Gazette notification supplement basket Andhra Pradesh 36 dated September 4, 2003 the opposite land survey number of Tapanpalli village as work property. I submit that the actor respondent notified the land. The number is bad. Without those very principles of nature. The land in question was neither non-land nor endowed as property at any time. It was private property and the petitioners to seven are linear descendants of protected tenant medical Ramaya in whose they were the owner to the action of the TSHC was granted with effect from 1/1973. The petitioners to seven are in physical environment of the time that has and include notification for without holding any inquiry and without notice to the petitioners 2 to 7. Thus, the include notification was issued in gross violation of the principles of natural justice. That the respondents have not conducted any inquiry as contemplated in Section 4 of the law plan and no opportunity was given to the petitioners 2 to 7 to explain their right. Thus, the notification issued under Section 5 of the law practice is illegal. That the respondents have failed to see the were registered protected tenants and acquired ownership rights to the lands in question, much earlier to the constitution of gazette, but no notice was issued to any of the petitioners before issuing the informed notification. This is the simple ground that is great. But that aspect is directly covered by the judgment of the Honorable Court, which was followed in this particular judgment, which I think you are not in government this case. Yes, just kindly just state. Gaura Reddy was to get the building, which is followed by the division bench. Paragraph 5, Lord in this Gaura Reddy.
Yes.
Petitioner submitted the notification as issued is in contravention of section 4 to 6 of Law Act 1954, and therefore it is illegal and not binding on them the extent of the land possessed by them. Hence, they seek declaration to that extent. It is also their case that they have purchased the land from various source, that is, by obtaining occupancy certificate which are issued after conducting inquiry by revenue duty officer, in which the original tenant, namely the son of Rakaya, was also a party who gave no objection but before the authority. Therefore, they submit that they are legal owners of the land in question, and the work code has no authority or power to issue notification. Even otherwise, such a notification is valid in law, as much as neither the original owner nor the petitioners could put on notice before issuing the impure notification. Moreover, the inquiry as contemplated under section 4 of the Act was not conducted by the survey commissioner, and therefore they they admit that they are legal owners of land in question, but of course has no authority power to issue the implement. Even otherwise, such a notification is invalid as much as neither the original. Therefore, they submit that such a notification is illegal and invalid. Counter affidavits, kindly omit that counter affidavit portion, Mirror. Then, Mirror, after scanning through the entire Act, the learned judge will not refer to paragraph 15, Mirror.
Yes.
In Muslim Waqf Board, Rajasthan versus Radha Kishan, a similar matter came up for consideration before the Honorable Supreme Court. The effect of sections 4 and 5 was considered by the Supreme Court in paragraph 25 of the judgment, which reads the very heading of chapter 2 and caption to section 4. No doubt suggests that the Commissioner makes only a preliminary survey regarding the existence of works and the list of works prepared by him. He is published by the board, and later the Commissioner not board is required to make an inquiry regarding the character of the property. That is to say, making survey is only an administrative act and not a quasi-judicial act. But on a closer examination, clear that while making survey of the existing works in the state, section 4, the Commissioner is required by section 3, subsection 3, to submit the report to the state government in regard to the several matters state to thereof. There may be a dispute as between the board and the Mutawalli or a person interested in the work as regards the existence of a work, whether the particular property is work property, whether it is a Shia work or Sunni work, the extent of property attached to the work, the nature and object of the works, etc. While making such an inquiry, the Commissioner is invested with subsection 4 with the power vested in a civil court under the Code of Civil Procedure in respect of summoning and examining of any witnesses requiring discovery and production of any document, requisitioning any public record, examination of any witnesses to account, making any local inspection or local, etc. In view of these comprehensive provisions, it is not disputed before us that the inquiry that the Commissioner makes for the purpose of submission of his report under subsection 3, while making survey of existence of works in the state under subsection 1, is not purely an administrative nature, but partakes of a quasi-judicial character in respect of the persons falling within the scope of subsections 1 of section 6. This is they have held that right, it's a quasi-judicial nature, that's what not is necessary. Then, my lord, kindly then kindly go to my lord paragraph 8, only for that purpose I think that can I read paragraph 18. Immediately, my lord, Mr. Vikrapati has said in paragraph 52, my lord, paragraph 32. Equation is maintainable. Paragraph 32. I am only concerned with the validity of the certificate. That portion you are asking.
Yes.
After half. I am only concerned with the validity of the notification published in the Gazette on 1989. The decisions referred to by the Senate Council of Court that the petitioners have to approach the tribunal or the civil court as the case may be, even after the expiry of 1 year period after the publication of Gazette notification, is not applicable to the present cases, as the situation would not arise in as much as when the notice itself is lacking and no purpose will be served by approaching the tribunal or civil court. It is also to be noted that the report of the survey commissioner sent by the government to the work court has no automatic acceptance. It is required to examine. It is required to examine such report before publishing the list. This statutory obligation is also totally lacking in this case. When the violation of statutory provisions is made out, it is always open to the parties to approach this court under 226 of the Constitution of India. And this honorable court, my lord, has said saying that as no notice was issued, the entire proceedings will be vitiated for non-observance of principles of natural justice.
Yes.
Can I read? It is when the notice itself just above that, your also notice itself is lacking. And no purpose will be served. After this, there is a judgment of Mr. Ramchandra Rao. Ms. Ramchandra Rao, but it is filed at page 119 of WP number 21889 of 2023. But in this case, what happened? As in the case, my lord, decided by my lord Vikrapati, they published the Gazette under 1954 Act. 1995, my lord, 1954 Act was repealed. My lord Ramchandra Rao has said, my lord, that you can't take steps under a repeal.
Yes.
Page 119, judgment start.
Now, what is the factual situation in this? Notice is issued. What they say in the counter?
They don't say that notice was issued, etc.
They say, did they answer that reading?
No, not at all. They did not say that notice was issued.
Counter is filed.
Yes. What is your stand? Notice is issued?
No, Milad. I'm not. There is no explanation on that aspect. But for saying that, Milad, the Gazette is published Milad, and we have categorically stated that Milad, now the writ petitioners Milad claim Milad from the protected tenants Milad having purchased the properties.
Yes.
Gazette Milad is notified as early as in the year 2003.
No, they are also protected. They are also before this court now.
Yes, Milad, their principal title Milad they claim from in the year 2009 when the 38E certificate is issued to them. It is after Milad the Gazette is notified. The Waqf is notified in the Gazette. May I draw my lord's attention to Milad a portion of affidavit Milad in.
No, what I am saying is the original PTs are also before this court questioning the same notification.
Yes, Milad.
They acknowledging their possession only, they were granted PT certificate.
Yes, Milad.
That means even prior to issuance of your notification, they were there.
In that aspect, may I clarify, Milad, section 4 and all that? If subject after my lords will hear the senior counsel.
Yes.
Lord, it's page 130. On internal page, follow the points for consideration.
Yes.
Points C, can I read the points? Whether the requisition is liable to be dismissed on the ground of lattice, whether the requisition is liable to be dismissed on the ground of existence of alternative remedy, whether the impugned visit notification dated 15/11/2001 issued by the first respondent on the basis of survey conducted by the Commissioner of Survey in 1963 when Work Act 1954 is in force is valid, notwithstanding the enactment of Work Act 1995 and the repeat by of the Work Act 1954. This is the crucial question that was decided. Whether subsection 2 of section 112 would save the impugned notification even after the repeal act of 1954, and whether proviso to section 4 of the answer to the Telangana area government of Toronto, respondent to be subject to vote. Then, my lord, kindly can I take directly to your lordships to the lord point C, which was decided. Paragraph 35(1).
Yes. Yes.
The impugned gazette notification issued by the first respondent states that the impugned gazette notification was issued on 15/11/2001 under the provisions of Work Act 1954, which has been repealed by Work Act 1995. Section 112 of Work Act 1995 states that the Work Act and Work Amendment Act 1984 are hereby repealed. Notwithstanding such repeal, anything done or any action taken under this act shall be deemed to have been done or taken under the corresponding provisions of this act. If immediate before the commencement of this act in any state there is in force in that state any law which corresponds to this act, that corresponding law shall stand repeal, provided that such repeal shall not affect the previous operation of the corresponding law, and such therefore anything done, any action taken in exercise of the power conferred by or under the corresponding law that be deemed to have been done or taken in exercise of the powers conferred under this act, so and so on. Then, not in BC Bhatia, the Supreme Court held that the provisions of the repeal statute cannot be relied upon after it has been repealed. It held that the effect of repealing a statute is to obliterate it completely from the records of the Parliament, as if it had never been passed, and it must be considered as law that never existed, except for the purpose of those actions which were commenced, prosecuted, and concluded whilst it was existing. So, it observed that what has been acquired under the repealed act cannot be disturbed, but if any new further step is needed to be taken under the act, that cannot be taken even after the act is repealed. Similar view has been expressed in Mohan Das versus So. Section 112 of 1995 is the nature of the repeal and savings provision. In agriculture and processed food products, Supreme Court explained that a saving provision clause merely preserves what exists. It quoted statutory interpretation. The learned author with regard to saving clause has said that a saving is a provision. The intention of it is to narrow the effect of the enactments to which it refers so as to preserve some existing legal rule or right from its operation. A saving resembles a proviso except that it has no particular form. Furthermore, it relates the existing legal rule or right, whereas proviso is usually concerned with limiting the new provisions made by the section to which it is attached. Again, in pages 494, 495, it is stated that the saving is taken not to be intended to confer any right which did not exist already. The Supreme Court said that this was the view taken by Shah Bhojraj and gaining factory versus Kumar. We have already noticed section 112 thereof states that notwithstanding repeal of the act, anything done or any action taken shall be deemed to have been done or taken under the corresponding clauses of 1995. The counsel for the second respondent contended that the survey was done by the commission under Act 1954 and 1963. That survey report was submitted to the government. It forwarded the same to the second respondent under section 51 of the Act. The second respondent examined the same and sent the list of work properties for publication to the commissioner, checking and so, Central Censor Board. He contended that due to paucity of funds with the second respondent, the publication in the AP Gazette could not be made as mandated by Act 1954 before its repeal, and it came to be done only on 15/11/2001 after its repeal by the Act 1995. So he contends that survey would survive the repeal Act 1954 and shall be deemed to have been done taken under section 4 of the Act. However, there is no dispute that the increased is issued on the basis of the survey report of the survey commission conducted in 1960, and same was published in the Indian Gazette on so and so, not under section 5(2) of 1995 Act, but under section 5(2) of Act 1954. In view of this, counsel for the petitioner contends that no publication in Gazette having taken place during the period when 1954 Act was in force, any survey done in 1963 would stand arbitrary. According to him, only if there had been a publication in the Gazette of the list of the properties pursuant to the survey report of the survey commissioner prepared in 1963, when Act 1954 was in operation, there would be a completed action which would be saved under subsection 2 of section 112 of the Act and not otherwise. According to him, mere survey report does not confer any right on second respondent unless it was acted upon during the period when Act was enforced. It would be only in incoherent action which is not saved by subsection 2 of section 112 of Act. He contends that savings clause would preserve only actions taken that are done under the repeal act and not other actions which are incoherent or incomplete. In view of the rival submissions, it is first necessary to consider whether conduct of the survey during the time when 1954 Act was enforced without publication of the same in the Gazette of the said Act conferred any right on second respondent or not. If answer is yes, and such right is saved under so and so and not otherwise, the issue was considered in Tamil Nadu Work Code. In that case, also a survey was made by the survey commissioner constituted under 1954 Act, determining that a particular property is work property, but no Gazette notification had been issued under subsection 2 of section 5 of that Act. Suits were filed by the appellate before the Supreme Court for recovery of properties, future main profits and costs. The trial court held that though the property in question is a public work, the notification dated 24/12/1958 issued under 5(2) of the Act did not include it, and so the appellant cannot recover positional property. This was affirmed in the first appeal. The first appellate court held that in the absence of proper notification under subsection 2 of section 5 of that Act, the suit properties for work properties, the appellant cannot succeed in the suit for recovery of possession. The High Court affirmed the same in the second appeal. The Supreme Court held that if any property is not published as work property as required under section 5(2) of the Act, Work Code cannot file a suit for declaration of possession. It is observed that if any property has been omitted from a notification, the Work Code may itself collect information regarding the property as provided under section 27 of 1954 Act and decide whether particular property is work property or not, and that decision is final unless revoked or modified by a civil court. But this course of action had also not been adopted by the Work Code in that case. It held that before filing suit for recovery of possession as provided in the Work Code should have followed the procedure as required under section 4, 5, and 6 or section 27 of 1954. In this case, also, my lord, 4, 5, and 6 and 27 have not been followed. If the suit properties are not included in the notification published under subsection 2 of section 5 of the Act, steps should have been taken as provided under section 27 of the Act. Only thereafter a suit for possession could have been filed and not otherwise. It therefore upon the decision of the court below. The ratio of this decision is that absence of proper notification under subsection 4, section 5 of the Work Act 1954 that the properties in question are work properties. Even if there is any survey report of a commissioner, the said report is of no avail and does not impress the property with the character of a work property. Whether the include gazette notification dated 15/11/2001 issued by the respondent on the basis of survey conducted by one second. Page number.
The page is missing, 23 pages missing.
I missed some pages. Sorry. Third, I hold I hold on point C and point D that subsection 2 of section 12 would not save the impure notification. That page.
Yes.
But ultimately, their lordships have held not. It will not save. But in this case, the same position. They say that survey was conducted under the 1954 Act. They published it in 2003 after 1995 Act.
Yes.
It is not saved.
Yes. What is the division bench judgment?
That Lord kindly comes to not the division bench judgment. They refer to these two judgments, Lord, of Kaura Reddy and the judgment of the Lord's Ramchandra. That copy given to your lordship, paragraph 10 on the right hand side, your lordship find. While dealing with the validity of products.
Yes.
Just now, the judgment which I read just now, my lord, is only 33133 of 2014 by order dated your lordship.
Yes.
Order. Kaura Reddy is also referred to. My lord, at page in page 231, my lord, your lordship. This quote in Bill Kaura Reddy, your lordship, my lord. I have shown to your lordship next paper, my lord.
Yes. Yes. Yes.
Your lordship.
Yes. Yes.
Extensively extracted. Kaura Reddy.
Yes.
For the foregoing reasons, again at page 233, page numbers are given at the bottom. After referring to Lord Punjab Waqf Board's case, the same contention which my land friend was referring to now was also referred to in this. Can I read Lord from your lordship permit?
మళ్ళీ ఏం చదువుతారండి ఎప్పుడుందో చెప్పండి అది మళ్ళీ ఆల్రెడీ రెడ్డి గౌరారెడ్డి అండ్ రామచంద్రరావు జడ్జ్మెంట్.
Right. Kaura Reddy is referred, your lordship permit. Kaura Reddy is referred at page 231 on the left.
Yes. Yes.
I'll not read again, Lord. Then Lord Punjab Waqf Board is referred in Lord there, same thing which extracts from that. Then Lord ultimately, one second. Lord kindly come to page 233 on the right side for the foregoing reasons.
Yes.
After referring to the earlier judgment, can I read?
Yes.
The writ petition is allowed as paid for the order dated 6/2/2012 passed by the legislature has been confirmed by the Indian bench. Recently, while dealing with the land survey number 302, received in respect of that land. One second. page 233 on the left hand. The third contention arises on account of the objection raised by the second respondent. The effect that the petitioners cannot challenge the notification at this stage when its rights to file a suit under the Act is barred. The question as to whether limitation and other aspects covered by section 4 to 6 of the Work Act would apply in relation to proceedings initiated by third parties also was dealt with by the Honorable Supreme Court in Board of Muslim Works Rajasthan versus Radhakishan. It was held that notification would become final and conclusive as between the Work Board and the Mutavalli on the one hand and the
అంతే ఎందుకండి ఇప్పుడు దీంట్లో పాయింట్ ఎక్కడ ఉందో చదవకుండా హౌ దట్ ఈస్ రిలవెంట్ నౌ
but his contention is restriction is not maintainable. This is what he is saying. Therefore, the contention of the learned standing comes that it is only the work action that can go into the validity or otherwise the case notification cannot be countenanced, and the same is rejected. This is what.
Yes.
This is the precise contention that he wants to advance now.
Yes.
They went to the question of alternative remedy. They cited judgments and said that such contention is not available. Here we got the three issues for 22A notification was quashed, gazette notification was quashed. Only for the purpose of deciding whether the ORCs are not issued, was issued after following the procedure or not was remanded back to the joint.
Yes.
Therefore, gazette notification under the Work Act is specified in this particular case, and it was applied by the division.
Yes.
This is how I say that this covers.
Yes. Yes, Mr. Joshi.
May I, Milad? Milad, at the cost of repetition, Milad, again, Milad, all judgments, Milad, are relied upon principally, Milad, from 1979 to SCC 468. That is Board of Muslim Waqf Rajasthan, Radhakrishna and others.
Yes.
Milad, the judgment was passed, Milad, in the year 1979 when 1954 Act was in force.
Yes.
Milad, 1954 Act was repealed by way of 1995 Act.
Yes.
But provisions in 1995 Act were minor alterations to the 1954 Act without contrary to the principal intent of 1954 Act.
Yes.
Now, Milad, two grounds are raised. One, they say, Milad, that the survey commissioner under section 4 did not, Milad, issue notices when the property was surveyed, and therefore, Milad, consequential gazette which is published is invalid.
Yes.
Two, Milad, they say that the survey commissioner conducted survey under the 1954 Act, and under the repealed Act, Milad, a notification is issued after the Act was repealed.
Yes.
Now, Milad, in context to these facts, Milad, 3 writ petitions are pending. There are 3 theories before my lords.
Yes.
Milad, the writ petitioners in WP, Milad, 21889 and the other writ petition, Milad, contend that they are the protected tenants and descendants of protected tenants, and subsequent writ petitioners are, Milad, having purchased from the descendants of the protected tenants is their case. They
Yes.
claim the property to be a private land. The rights of protected tenancy, Milad, granted by the RDO. Basing on that certificate, subsequent sale deeds were executed, and basing on the sale deeds, they claim their title in the property.
Yes.
Milad, the revision petitioner in CRP 1127, Milad, claims to be descendant of, Milad, one gentleman who he says that the lands are patta lands.
Yes.
His predecessor in interest was the patadar of the property, and that he is descendant. And they have got inter alia dispute among themselves that the 30th that the proceedings of the Tenancy Act was not properly followed and all that.
Yes.
But all that aspects apart, Milad, it is the contention of the Waqf Board that the property, Milad, is a Waqf property duly notified in the Gazette pursuant to, Milad, survey conducted by a survey commissioner.
Yes.
Now, my lord, coming to the grounds raised by the learned counsel for my lord petitioner, may I request my lords, my lord, to take up my lord old act section 4, 5 and 6. My lords, the only difference between provisions under section 4, 5 and 6 of the Waqf Act 1954 and the Waqf Act 1995, my lord,
Yes.
under section 5 of the act, my lord, initially the survey commissioner appointed by my lord, the government would survey the properties, send a list prepared by my lord after the survey is conducted to the Waqf board. Waqf board was required to verify it and resend it to the government for publication. After 1995 Act, my lord, the board itself was required to publish.
Yes.
Minor difference.
Yes.
Then, my lord, in section 6, old 54 Act section 6 also said that publication was required to be made under section 5 and that the persons interested could challenge the publication within a stipulated period of 1 year from the date of publication.
Yes.
In 1995 also that particular provision continued.
Yes.
In 1995 tribunals were formed.
Yes.
In 2013 section 6 was amended.
Yes.
Instead of persons interested, any person aggrieved terms were incorporated in the law.
Yes.
Now, the judgment, the principal judgment, which is relied upon in passing Gaura Reddy or for that Shri Ramchandra Raoji's judgment or the division bench judgment.
Yes.
Principally all these judgments rely upon Board of Muslim Waqf Rajasthan.
That is a forum. That is with regard to forum.
No, if I may clarify.
Yes.
My lords may feel, my submissions are against the tide, but for 2 minutes, if my lords may bear with me, I will try to satisfy my lords.
Yes.
My lords, in 1974, it was understood that any person who is interested in the Waqf only could challenge the Gazette notifications.
Yes.
Now, basing on the provisions then existing, these judgments have 1979 judgment has come into play.
Yes.
The facts of the case were that a third party challenged a notification, Gazette notification in the Honorable High Court, stating that he did not come within the meaning of person interested, and therefore he was not bound by the Gazette, and therefore he had a remedy available under section 226 of the Act of the Constitution, Article 226 of the Constitution. Understanding the set of facts in the light of provisions of Act of 1954, the Honorable Court said that yes, he was not incorporated within the meaning of the term person interested, and therefore he had a remedy under 226.
Yes.
Now, the action is brought before my lords by way of a writ petition dated 2022 when 2013 Act is in force.
Yes.
2013 amendment grants an opportunity for the persons aggrieved to move tribunal challenging the notification.
That is on the remedy. Your submission.
Yes, on the remedy. For movement section C, section 4.
Yes.
In 79 judgment, that is the Board of Muslim Waqf Boards.
That is on the count of remedy. Your submission is on
on count of remedy as well, on the aspect where the court decided that it is not only an administrative act but quasi-judicial act. On that aspect as well.
Supreme Court recently also held that writ petition is maintainable.
Writ petition is maintainable in circumstances only where there is a breach of the provision.
Yes.
If I may say so.
Yes. Yes.
Not otherwise.
Yes. Now the allegation ground is only that.
So, my lords may have to, in the light of set of facts now presented by the petitioners, my lords will have to see, whether the notice was required to be issued by the commissioner. Yes. In the light of provisions under 1954 Act and 1995 Act.
What do you say on that survey under the 54 Act and you published a Gazette notification under the Repeat Act?
My understanding of language applied in the Act is
What is your understanding of judgment of Justice Ramchandra Rao?
I believe that I would like to, with due respects, differ from that.
Is there any appeal filed there against?
There is an appeal filed, I will provide the number.
What happened to that?
It is not handy with me. I'll provide it.
So that has become final or not?
No, it is not yet final, my lord. I have got, there is an appeal file, my lord. I will provide that number. It's not handy available with me. I'm sorry for that.
Is that stay of granted against that order?
I'm not sure, my lord. I'll verify and get back.
Division bench of this court followed the judgment.
Yes. My lord, one more judgment referred, that is 33133, my lord. It is challenged, my lord, and interim directions not to create third-party charges in respect of the property covered under a writ petition is given. That order is there.
Then to that extent, it is now stand covered.
It is covered, my lord, but I leave it to my lords, my lord. My only submission is all those judgments, my lord, derive principle from out of that judgment which is passed basing on 1954 Act. Now that, my lord, the circumstances are changed and they move, my lord,
I'm bound by that the law laid down by other learned judge.
But even for a moment, if I may, my lord, section 4 of the Act, if my lords may peruse, 456, my lord, for a moment.
Yes.
Like old Act I am reading, my lord, 54 Act.
Yes, same provision, right?
Same provision with minor changes.
Yes.
May I read, my lord, 4?
Yes, yes.
It is preliminary survey of works. The state government may, by notification in the official gazette, appoint for the state a survey commissioner of Waqf, as many additional or assistant survey commissioners of Waqf as may be necessary for the purpose of making a survey of Waqf properties existing.
Yes.
In the state at the date of the commencement of this Act. But my understanding of the language applied is, a commissioner, additional or assistant commissioners as may be required shall be appointed by the state government for conducting survey. The condition precedent for a commissioner to survey a property is that the property must be a Waqf.
Yes.
Then, Milad. 2. All additional and assistant survey commissioners of Waqf shall perform their functions under this Act under the general supervision and control of the survey commissioner of Waqf. 3. The survey commissioner shall, after making such inquiry as he may consider necessary, submit his report in respect of Waqfs existing at the date of commencement of the Act, that is subsequently incorporated, madam, to the state government containing the following particulars. Now, Milad, survey commissioner is directed to conduct an inquiry. Milad is vested with the power to conduct inquiry. The word inquiry, Milad, used here is subject to, Milad, 3A to F incorporated in the Act.
Yes.
So, insofar as to powers conferred by the statute.
Yes.
May I read those, Milad? The number of Waqfs, showing the Shia Waqfs and Sunni Waqfs separately, the nature and object of each Waqf, the gross income of the property, the amount of land revenue, the expenses incurred in realization of the income, such other particulars relating to each Waqf as may be prescribed.
Yes.
Milad 4, 5, subsections 6 also, Milad, of section 4. Milad, none of the subsections or the provisions or the language implied in the Act empowers a survey commissioner to conduct an inquiry as to whether a property he is inquiring upon is a Waqf or not.
Yes.
Then my lords may see section 5.
What is that survey is supposed to do?
But he is supposed to conduct survey in respect of existing Waqfs only in respect of, Milad, powers assigned under section 3A to 3F. That is my understanding.
Yes. What is the deviation difference between this 54 provision, section 4 in 54 Act and 1995 Act?
There is no difference. 4 remains the same.
Yes.
Only 5, Milad, is different. May I continue reading, Milad?
Yes.
Subsection 4, Milad, I am reading 4.4. The survey commissioner shall, while making inquiry, have the same powers as are vested in a civil court under the Code of Civil Procedure.
Yes.
Now, Milad, the inquiry is in only context to 3A to 3F.
Yes.
While conducting such inquiry, he is vested with power as that of a civil court. The powers, Milad, are described under 4A to 4F. That is to summon discovery, public inspection of public record, commissions, local inspections, so on and so forth.
Yes.
Then, Milad, 5 and 6. if during such inquiry any dispute arises as to whether a particular waqf is a Shia waqf or Sunni waqf, and there are clear indications in the deed of waqf as to its nature, dispute shall be decided on the basis of such deed. Now, Milad, had the framers of law intended, Milad, to vest power whether with the commissioner to decide whether a property is inquiring is waqf or not, Milad, a specific and categorical provision, Milad, would have been incorporated in the statute, which is otherwise now. May I proceed, Milad, further?
Yes.
Yes. The state government may, by notification in the official gazette, direct the survey commissioner to, that is regarding second survey, Milad, it is not relevant now. May I proceed for 5?
Yes.
Yes. Publications of list of waqfs. On receipt of a report under subsection 3 of section 4, the state government shall forward a copy of the same to the board. 2. The board shall examine the report forwarded to it under subsection 1 and publish in the official gazette a list of waqfs in the state so and so, so and so. Earlier, Milad, in the 54 Act, it was, Milad, the board was required to, Milad, resend it to the government, which would publish the list in 54.
Yes.
That is the only difference between, Milad, 54 and 95 Act.
Yes.
Then, Milad. Now, Milad, the process is like this. A survey commissioner will have to enter upon a waqf property, inquire into the matter, submit a report. The report, a list is prepared. The government will forward a list to the, Milad, waqf board. The waqf board is required to scrutinize the list and send it for publication.
Yes.
Under 5(2) of the Act.
Yes.
The board shall examine the bill. Now, Milad, the list which is prepared under section 5(2) of the Act, Milad, confirms the character of institutions and properties enlisted therein to be a waqf.
Where do you get that?
May I read, Milad? The board shall examine the report forwarded to it under subsection 1 and publish the official gazette a list of waqfs in the state, or as the case. In six, my lords will find it. In 6, my lords will find it.
Yes.
I mean, please be permitted to 5(2), Milad. Read 5(2).
Yes.
The board shall examine the report forwarded to it under subsection 1 and publish in the official gazette a list of waqfs in the state as the case may be, the part of the state, whether in existence, so and so, so and so, so and so. Then, my lords, may see 6.
Yes.
Disputes regarding waqfs. If any question arises, so and so, I am having a text along with, Milad,
Yes.
please pardon me if I am reading other.
Yes, please proceed.
Yes, yes. If any question arises whether a particular property is specified as waqf property in the list of waqfs published under section 2, subsection 2 of section 5, my lords found it?
Yes. Yes.
If any question arises whether a particular property is specified as waqf property in a list of waqfs published under subsection 2 of section 5 is a waqf property, my lords, the statute does not say which is gazetted as a waqf property or not. It says enlisted under subsection 2 of section 5.
Yes.
Is a waqf property or not, or whether a waqf specified in such list is a Shia or a Sunni waqf, the board or the mutawalli of the waqf or any person interested therein may institute a suit in civil court so and so, so and so, provided that no such suit shall be entertained by civil court after the expiry of 1 year from the date of publication of list of waqfs under subsection 2 of section 5. Provided further that in case of list of waqfs relating to any part of the state and published purporting to have been published before the commencement so and so, so and so, so and so. Now, Milad, in the light of these provisions then subsisting, the principles were drawn. Now, 1995 for a moment, my lords, see. Now, only difference in 1995 subject to 2013 amendment is section 6 and section 5. That the aspect of publication, and then, Milad,
yes,
the persons who may, Milad, question that particular notification. Now, my submission in the light of these provisions is, Milad, series of writ petitions are being filed challenging a gazette notification. But my understanding of the provisions is, But the list which is prepared under section 5(2) of the Waqf Act, be it 54 Act, be it 95 Act, subject to any amendment, because the principal language is not changed. Milad, that particular list, if the property or institution is Milad finds placed in that list, that particular list creates or embodies the character of Waqf or confirms the character of Waqf on the institution and properties enlisted therein.
Without notice the person in position.
Milad, I may say, Milad, the commissioner is Milad under the statute, by the statute, required to perform a limited inquiry.
That's fine. That's the query is, if the survey commissioner enters upon my property and conducts a survey and submits a report without notice to me, and that is published.
If I may say it otherwise,
Yes.
if a commissioner has to enter upon a property, the
Yes.
language of section 4, Milad, it is a condition precedent that he must enter only upon a Waqf property.
That's what I'm saying. If he enters upon a private property and submits a report and you publish it under 5(2), then it assumes the character of Waqf property.
No, my lord is right. If I am entering upon a private property, my lord is
Yes.
right. But I am not permitted to enter upon a private property because
So mere publication in the under 5(2) will not confer the status of a Waqf unless it is otherwise treated as a Waqf property.
now,
For procedure.
therefore, Milad, section 6 is incorporated. Milad, with a right on the parties, Milad, who are aggrieved to challenge such list.
Anyway, even if the
notified
procedure
subsequently.
is not contemplated under 4, when you are dealing with a property which is in possession of somebody, and principles of natural lease are bound to be read into it.
Unfortunately, the statute does not empower a commissioner to do that.
Yes, does not, but you have to read into it. Otherwise, you are depriving a property of a citizen without putting him on notice and relegating him to litigate into the
Milad, without admitting, but considering for a moment. Without
Yes.
admitting, but considering for a moment. Milad, even the protected tenants are.
Please answer the query. If the survey commissioner submits a report in respect of a private property and you publish it under 5(2), what will follow? What should happen to that?
But it is my contention, Milad, that the survey commissioner cannot enter a private property. Condition precedent for him to conduct a survey is that he must enter a Milad Waqf property.
Yes.
So therefore, Milad, the framers of law have incorporated section 6.
That means that property should be a Waqf property even prior to procedure application of section 4.
Yes. The language implied says so, Milad, not me.
Yes,
My lord, for a moment, my lords may see the language.
Then you have to satisfy that DHOS this 5(2), the subject property is a Waqf property. On mere publication under 5(2), you cannot claim that this is a Waqf property.
That aspect is there, Milad.
Yes.
That aspect is there. Milad, insofar as to Milad repealed act and new act is concerned, only 2 submissions. My lords has already examined Milad those 2 judgments, Government India and Indore Municipality.
Yes.
Milad, my submission is, if the repealed act is not in contravention, Milad, if the new act is not in contravention or contrary to the repealed act, or carries the same intent and same language, Milad, then that particular Milad precedent may not apply. That aspect is already covered, Milad, in that judgments.
Yes.
Only that, Milad, I want to submit. I rest.
Where is that Government India?
I will file it, Milad. I will furnish another copy. My lords has already heard, Milad, Shri
So you
Mayur.
want me to carry that copy in every case?
I will carry it.
Because you cited it in another case.
I will carry it, Milad. I am sorry I am handicapped with a copy, Milad, today. My apologies.
Tomorrow. Get.
That my management rate has been dealt with without the.
No, there is another judgment, Government India, I think.
That is the difference.
Yemen India and Indore Development Municipality.
One should go to Supreme Court or not, has been considered.
No, recently also Supreme Court held that writ petition is maintainable, questioning the one need not approach Waqf code.
The honorable
tribunal.
judgment referring to not AC state Waqf versus Hyderabad. Archdiocese Society 2010 HCC online HPQ. So can I just read
No,
once?
that is there, my lord. Those judgments are there.
Standing counsel for foreclosure. Tuesday.
Tuesday, when?
Tuesday.
Tomorrow?
Tuesday.
I'm obliged, my lord. I'm obliged.
Item 20. Srinivasa Rao.
Past Tuesday, sir.
And 22 years. 2 weeks, draft we were last week. You're taking time to find reply. Reply is ready.
What happened?
On the file, the
Registration of a document.
Yes.
Registration.
Yes.
Document is presented.
Written that the not with the other complement only about disposal on the ground of validity, they cannot receive. They are not fulfill the municipal.
Document is returned.
Next week,
The intent is inside how many times?
this week, draft was ready. The rest of your application could not come.
These matters are listed last week also. Last Friday.
Next week, suffering from fever, he could not come here to sign the match.
The refusal order is passed.
Yes, sir, that's it now.
Yes, if you are agreed, you have to take steps on that.
Sanction plan, you are looking at the. Try to take it up next week, you'll still try to reply.
Yes, sir. It was for land council for the petition.
20th.
2020. Yes.
Item 21. P. Damodar Reddy.
Yes, was rejected.
So that is for the original violation of the order for site WP number 2.641. 14th September 2022. Wherein this court directed the respondents to
Item 23.
20. Also online application.
Yes. Before filing of the petition, that the already converted into plots, petition and so to the third parties.
The order passed.
Details for now. Page 7 of the
But reasons have to be given.
result in the order. Is not entitled to the retaker, make the executor access to the application. Document for it. It shows the property.
What documents?
Easy. Income letter,
Where is EC?
page 6. Just to buy. Then it's the PDF of SCS pattern pages. Sorry. Yes,
Order, the recent order is required to be passed. So that he can take steps if agreed. This is the. But చెప్పాలి కదండి అది. You cannot question your counter affidavit.
But it is the order is that they are our. But it is the part. It's like pressing the
Counter file. Notification competition. Item 24.
May I please your lordships?
Yes.
But this contempt is filed, my lord, complaining the disobedience of the orders dated 3rd March 2023. But in a writ petition number 36065 of 22, where a common order was passed, my lord, when the unofficial respondents played fraud on this court and obtained an order in their favor, there was a review filed by me, that clubbing that review along with this writ petition, that an order was passed. My lord, kindly, Lakshmi, kindly go to the order is
Yes.
at page number 11.
Collector was approved today morning that the petitioner also applied for slot booking.
It's under.
I have also filed additional affidavit, my lord. I have also filed additional affidavit, bringing it to this honorable court's notice that they have rejected my application, saying that it's not in order, one thing. Second thing, my lord, they also, my lord, convert the land into non-agriculture, basing on an application filed by the other party.
He says at your instance, slot is booked today morning. And they are going to do it.
My lord, I have no information.
See, get instruction. Please.
Obliged. Next week, ma'am, I will take it.
The petitioner hearing has booked the slot today morning, and the respondents are in the process of complying with the order passed by this court. Yes. Close the matter on next Friday. 17. Yes.
Item 25. Kim Madhusudan.
have filed in this case, stating that corporation is not appearing. So, appear the order at your page number 8. Without following due process of law, the respondent shall not interfere with the subject property.
Yes.
But the corporation had issued a notice, my counsel only minute a notice was issued stating that the building condition is under dilapidated condition to take preventive measures. That's all. More than that, the notice itself filed by the petitioner, contempt petitioner under section 459 of TSHC.
What you said about the photographs filed by them?
The photographs filed pertaining to the different property, and whereas themselves they admitted that the 459 notice was issued to all, and the structures were demolished with the remaining properties, not with the petitioner property.
Counterfile. First of the council, but the post of 17.
Item 26, Ramon Bagi.
Last 17.
15.
Next coming Friday, because the 7 up to 8.
20th?
Yes.
20.
26 with time for getting instructions and hearings. Counter has been filed by them on 4th of October.
Regarding the identification of the government and the petition that was done, taking this here, counter.
They said they can't do the survey because it is converted to non-agriculture. That's what they're saying.
The government and the
They say it's in my presence, Manish, which is aspect instructions.
What do you want?
I need a time for the hearing.
Why?
Get instructions from the client of whether we were present in the survey.
When counter was filed?
4th of October.
Then 1 month is not sufficient. Yes. Which paragraph in the counter?
The government signboard has been erected in the government.
Because it's referring to a Panchkama Melody and Bharatpur and not filed.
If non-agriculture land, no survey can be conducted. Why?
But it will be done.
Why? So every land converted into non-agriculture will become part of municipality. Yeah?
No.
What is the direction of the
Identify the both petitioner land and government land. Petitioner is
land is available belonging to the petitioner and
It was done in my presence, but no specific date has been issued for that, and Panchkama also has not been filed. Show that actually a survey was conducted.
what is your allegation now in the contempt?
Well, it's they did not remove the board.
Read that allegation.
In spite of being aware of the order dated so the respondent failed to remove the board and also to cause surveying subject property as directed by honorable court. At the same not only reflects this is a major
They will not even reply to my contact.
Yes. There are 5.
4 military theaters. 12/6 total and the third person of the purpose of we erected to the land creation field, leading to the extent of 3 meters, which is under replacement. The government trying to be erected to
Where is the direction? How can you, the court directed you to conduct survey? Where is the question of submitting an application and then? It's for you to ensure that proper survey is conducted. Merely because it is non-agriculture land, you cannot just wash your hands. There is a direction. And, there is a direction to remove the board also. You say that it is not in the government land. Yes, ma'am. It's filed by the response. Prima facie it appears. And the direction to conduct survey, how can she say that you should make an application, this, that, and immediately board is not removed. Yes, Form 1, 4 weeks, let them do. Yes, but if they want to do, let them rectify. I mean,
So directed to consider my application and pass upon the it's an online application.
yes, what they say?
They say that for page number 2 of in their person was saying that format is wrong, which I tried. And your also direction is given notice and consider. So if you say that at their time, so far he has not seen my application and not given any notice. First time is after filing the counter, he says that it's not in formal work. Page number 5. TM15 application has to be filed.
You file.
No, for the first time they are saying it is. And
First time when in the counter they said,
yes,
what petitioner did after that?
it's not filed.
Then you should have filed.
Yes, you also I will file. You will also grant some time. Thereafter, let them consider. Recently, counter is served.
Recently, sir, 2 months back.
So it was.
29th September. So, I'll close the country.
That's why I definitely file under.
You have not filed.
Yes.
You want to.
Oh, I file not let them consider it with 1 month or 6 weeks.
Other matters. 10-6 to 11.
Yes.
All of these cases will also be timing cases. Case 467.
Yes.
It can be depend upon the actual aspects. But it's to be getting my submissions on the four aspects.
Yes.
And to really whether the petitioners claiming to be an association. It's the first petition in WP 4867 is Terillapur G Block Plot Owners Association represented by Mr. Branch. Some individuals, petitioners to fight.
Yes.
But what the petitioners claim is that they have purchased plots from Industrial Employees Cooperative House Building Society. Lots of from the entire affidavits of these petitioners, other than by lots of the persons whose names were referred to in section 4 notification. After different extents of land, 1 acre. Like that, my lord, they are also filed such a petition. These source of title which has been set up by the so-called purchasers from the so-called society.
Yes.
My lord, sir, the absence of the material particulars as to the objectives of the society. The society which is registered, that the AP Cooperative Societies Registration Act as then was, how it acquired this much of extent. There are certain ceiling laws, they cannot bypass them. What were the requisite permissions the so-called society obtained? Exemptions obtained. What for they conceived the idea and who are the members of such society for whose benefit the society intended to acquire the property. In the absence of that material particular, the entire affidavit itself is quite vague, lack of material details.
Yes.
Such, my lord, such is the foundational aspects as to the title.
Yes.
Of the so-called purchasers or even the society.
Yes.
How did the society acquire? When did the society acquire? When did the society obtain layout? From whom the layout is obtained?
Yes.
When it was obtained?
So you are referring to petitioner number 1 society?
Society, my lord, sir, are petitioners who are claiming title through the society.
Through Industrial Employees Cooperative.
Yes.
Yes.
But I will read out from the affidavit, my lord, which is filed in the impeding petition.
Yes.
Therefore, in the absence of, my lord, a clear disclosure, a valid disclosure, a valid title or other interest in this property, that is 92 acres, 39 guttas land. Of the so-called purchasers, nor the Industrial Employees Cooperative House Building Society. Perhaps they cannot be regarded as a person interested to claim compensation.
Yes.
There is a serious, admittedly, there is a serious dispute between the society or the purchasers and this, my lords, the Sai Krupa Enterprises, which name was entered into the revenue records as purchaser of the property. And subsequently, my lords, certain proceedings are claimed to have been initiated
for change of mutation, but that was not implemented in the revenue record so far.
Yes.
My lord, sir, from the applications which have been filed, IA claiming to be the interested parties. From this, my lord, something can be called out as to how the properties have been traced.
Yes.
Sourcing the title. That's IA to your lordship may kindly take, including parties have filed. They filed certain documents, my lord, because
Fine, Nagesh. Vinay is copying. Yes, yes.
IA to your lordship may speak. Well, this the petitioner will list not to be included being the successive purchasers of the plots. But at the outset, my lord, the sale itself is void. But if you look at the document, my lord, executed by the so-called industrial employees cooperative house building society. I'll just take my lord's your lordship's kind attention.
Yes.
Parent document. Somewhere they say it was purchased in, layout was made in 65, someone says in 70s. No layout has been produced.
Yes.
Yes. That is page 32, my lord, one document that is sale deed got to be relied on.
Yes.
Sale deed made and executed is the 30th day of March 1984 by the Industrial Employees Cooperative House Building Society. Sangareddy, Hyderabad and Post. So, represented by President Sri D. Narayan Rao.
Yes.
Son of Ramarao, occupations. President Cooperative Society, President of Pananjaru is duly authorized to execute the same dates as per the resolution of the committee dated 10/9/82 in favor of Vikar Nisa, the Vycox Resource, aged about 27 years. After the other part.
Yes.
Whereas the society acquired the land measuring 3 acre 3.36 acres equivalent to hectares through document number 1801 of 83. In survey number 331 situated Tellapur village, Sangareddy district. So, in this regard, free from all encumbrances. This sale deed is not produced. Who has acquired the title? In page 33.
Yes.
That's from the bottom. About 8-9 lines in witness whereof.
Yes.
In witness whereof the society above named through its president and has set its hand the common seal of the society at Sangareddy so and so. The day, month, and year first above written. Note, my lord, there is a note in the sale deed. Layout approved by Gram Panchayat Tellapur dated 1/7/1977.
Yes.
My lord, if that is the case in 1977, there is this layout approved. What should have been the property to be conveyed under this document is plotted area.
Yes.
Whereas the agricultural land is referred to have been purchased.
Yes.
My lord, those certain pleadings, my lord, in fact, there are other repetitions which were disposed of by this court. My lord, certain aspects were not pleaded in different cases. Certain pleadings have been made. Though they are, it is my duty to bring it to your lordship's kind notice about
Yes.
certain aspects where my lords, there was a house committee appointed. That is not part of the record, my lord, but I'll show lordship by filing that document. There was a house committee appointed. House committee, my lords, gave findings that the society was bogus, and there was a direction to inquire to the to
No, it's not that society was bogus. Society purchased assigned lands and assigned in favor of political sufferers, ex-servicemen, and also landless poor.
No, my lord, Patta land was also one of the part of the
Patta land.
acquired.
Patta land was also, this court already declared that Patta land cannot be subject matter of an inquiry by the House Committee.
Because Patta lands, the government, other than the government land, that cannot be inquired.
House Committee's scope is only in respect of land assigned in favor of landless poor persons. Yes.
But with regard to the society,
Yes.
there is a categorical finding by the House Committee. It is a bogus society.
Yes.
And the members are bogus members. As the society, what should have been conceived by the society, even from reading of, I'll take your lordship to certain material aspects. The society intended to acquire the land for whose purpose?
Yes.
For the weaker sections of the society, for the members who are working in the factories nearby,
Yes.
and who are the below, my lords, 15,000 or so, that is also referred in that. For those persons.
Yes.
Where it is, my lords, the petitioners should have filed all the society's bylaws, regulations, the exemptions obtained for acquiring the land.
Yes.
That's in the absence of those material documents, we cannot assume on the basis of a registered instrument that there is a valid title. By registration of a document by itself does not mean that it is valid in the eye of law, or to construe that there is a valid title in favor of the person named, either in favor by the vendor or the vendee.
Yes.
Since the affidavit do not disclose, my lord, there should have been a categorical disclosure of material facts.
Yes.
Because I take from this document itself, because they should have filed all these documents. Petitions who have approached this court should have filed all these documents. But somehow, my lords, that the documents have come before your lordship at the instance of the pleading parties. And at page 24, this is one sale deed executed by the society.
Yes.
Well, these pleadings have not been made, but it is my duty to bring it to your lordship and notice about the material aspects which were not there on the record.
Yes.
The court may have to consider these aspects also, and before they challenge the acquisition proceedings. Let us pair one at page 24.
Yes.
Whereas the society acquired the land measuring 3.36 acres equivalent to hectares through document number 83, situated at Jallapur village, Taluk Sangareddy district, which was purchased for housing purpose to the industrial employees of Jallapur village, Taluk Sangareddy.
Yes.
My lords, the petitioner, the so-called purchasers before your lordship did not say that they were the industrial employees.
Yes.
Therefore, my lords, there is a suppression of a material fact. This court cannot consider, nor any court can consider,
Yes.
a title so as to challenge the land acquisition proceedings for the entitlement as to the compensation.
Yes.
This document of 84 clearly disclosed that the society itself has purchased the property in the year 1983 for the benefit of its members who are industrial employees.
Yes.
From the array of my lords, the plot owners' details, most of them it can be safely concluded that they are not the industrial employees nor residing nearby to those industrial areas.
Yes.
And this material particular is deliberately suppressed.
Yes.
my lord, sir, from this affidavit, the petitioners affidavit, my lord, from this IAP, brief facts. There are five, my lord, page 5, there are 3.
Please.
It is submitted that Industrial Employees Cooperative House Building Society had purchased an extent of acre 326.37 guntas of land in survey number. Well, that's no disclosure as to when did they purchase. And obtained a layout from Gram Panchayat on 15th March 1965.
Yes.
That's in the absence of a proper claim before this court. The petitioners have no locus at all. None of the purchasers from the society,
Yes.
the so-called society. And as far as this IA, why I have read my lord, because it shows some light, it throws some light on certain material aspects.
Yes.
Coming to the affidavit. Yes. Writ affidavit. Writ affidavit, my lords, it lacks material details as to the title. Yes. My lords, the affidavit of Mr. U. Rajendra, who deposed for all the petitioners. The petitioner number 3. There are 4 men.
Yes.
It is submitted that Industrial Employees Cooperative House Building Society, Bandlaguda, a society registered under the provisions of Andhra Pradesh Cooperative Society Act 94 with registration number so and so. The said society acquired an extent of acre 326.37 cents of land in survey number so and so of Tellapur village, Ramapur. The said society obtained layout from Gram Panchayat on 15th March 1976.
Yes.
Whether the society could have obtained such a plan, my lords. The subject to property
Yes.
falls under, my lords, the but my lords, under the development area, under the Urban Development Act, my lords. Therefore, the so-called, my lords, setting up of case by the so-called petitioners from the society under, my lords, a purported layout of 1965 and 76.
Yes.
The society doesn't, my lord, there is no title deed placed before your lordship. That the society acquired the land prior to 1965 or 1976.
Yes.
Rather, the sale deeds contain, whereas the layout has been given, taken in 76. Tellapur 77. In the sale deed, my lord, it is 77. My lords, while construing the rights, my lords, there is strict construction as to the title.
Yes.
Setup must be considered since nothing has been placed before this court. My lords, the challenge itself is misconceived as they do not themselves have no valid title or other interest.
Yes.
My lords, these documents which I have read to your lordships rather show that the larger extents of land were acquired by Mr.
Yes.
Narayan Rao under various theories. 360. How is that, my lord, that they can acquire the land in the absence of valid permissions under the sealing laws?
Yes.
Therefore, Mr. Narayan Rao or the society could not have conveyed a title in favor of the person, the petitioners.
Yes.
And there is no reference at all that they are the industrial employees.
Yes.
Well, that's how the amendments proceeded. 7. It is submitted that the government acquired the lands in survey number 11. Various survey numbers of Tellapur village for the purpose of development of Tellapur residential complex. The said land was entrusted to the second respondent for development. The second respondent prepared the layout and offered the said lands to public for sale by way of public auction during the year 2004. The plots were sold in the range. This is only to show that the adjacent areas were sold for a price. Probably, my lord, their idea may be to have that rate of compensation subject to they succeeding in before the my lords the authorities or the civil court as the case may be, because there is a rival claim.
Yes.
It has no relevance at all. My submission is there are 8 my lords. On section 18 of the Urban Areas Act, my lords, I was directed to your lordship that it is hit under 18. It is not so, my lord, because the same thing has been deliberated and my lords discussed in various judgments of this court and to the Supreme Court. I read to your lordship those principles laid down and the ratio laid down. And the objections raised, every aspect my lord raised with regard to vagueness, with regard to my lords the purpose, and with regard to the my lords the change of land use. They can't rely upon that, my lords. Even there is also, my lords, there is no clarity at all. I'll take your lordship to the later point of time. Let me read the pleadings, my lord.
Yes.
It is submitted that the second respondent herein is constituted under the Andhra Pradesh Urban Area Development Act 1975 for the purpose of development. Andhra Pradesh. According to plan and other connected matters, the second respondent was conferred with the power to conduct surveys, prepared master plan for development area, zonal development plan, and submit the same to the government for approval. Under section 13 of the said act, no development of land within the development area can be undertaken by any person, authority, except with the permission of the second respondent. And after obtaining permission under section 14 of the act. The section 18 of the act, the government may acquire land for the purpose of development, and lands so acquired may be taken possession and then can be transferred to the second respondent on payment of the compensation and charges incurred by the government in connection with the said acquisition. Under section 19 of the act, the second respondent is empowered to carry out such development and dispose of the same in the manner prescribed under section 19(2) of the act. Though the object for which the urban development authorities are constituted are very laudable and are intended for the purpose of systematic development of the urban area, the second respondent had shed the said character long time back. Now the respondent is the official real estate of the government in indulging in indiscriminate acquisition of pata lands and dispose of the same by public auction only with a view to earn revenue for the state. As part of the professed grand design for development of a township in Tellapur village, the second respondent had proposed acquisition of the land belonging to the society, apart from the land allotted to it by the state government. State government had allotted an extent of 400 land to the second respondent for the said purpose. Pursuant to the said decision, the second respondent approached the first respondent herein for acquisition of an extent of 92.39 cents of land, which is abutting the land allotted to it by the state government. Acting on the requisition given by the second respondent, the first respondent herein issued a notification on section 4 of Acquisition Act for proposing to acquire 92.39 cents of land in survey number so and so. My lords, para 8 itself, the petitioners are fully aware the purpose for which the Urban Areas Act has been enacted. And this land, why it was proposed, clearly said by the very petitioners. My lords, whether the grounds which have been stated are relied upon.
Yes.
As any legal substance, my lord, that your lordship may have to consider. There are 9, my lords. There are 9 speaks of the dealing with the 5A objections. 10, my lord, has some relevant for the adjudication of this case. It is submitted for 10 minutes. It is submitted that the decision taken by the first respondent to say the least cannot be called a decision, but it is reiteration of the contents of the notification. The first respondent concludes that the acquisition is for the purpose of catering to the needs of general public, which on the face of it is a blatant lie. The acquisition is for the purpose of real estate development by the Huda and the government.
Yes.
Such a contention on the part of the petitioners who do not have minors. From the reading of the documents and the writ affidavit, no semblance of a valid right. You yourself do not have a right.
Yes.
And you source your title from the purchasers from the society. And you do not say at all as to my vendor was an industrial employee. The society has lawfully acquired. The absence of my lord, the due diligence which is required to be followed by a citizen of the country, my lord, as the principle of caveat emptor absolutely apply. And my lord, in the absence of material details, it cannot be construed as a person interested. Such a person, my lord, sir, whether they are entitled to say that the acquisition is for the purpose of real estate of the Buddha and the government. It can never be, my lord, such an intention of the Urban Development Authority or the government. And even, my lord, there can be a commercial element. My lord, the ratio laid down in number of judgments. There can be a commercial element. Even the government can enter into contracts for the purpose of commercial aspects as provided under Article 299. My lord, sir, which every common man in the state knows. I do not know, my lords, why, how he happened. I do not know about this. But perhaps the office held by him would not allow the district collector to accept the setback. Further, the first respondent hearing is aware of the fact that the second respondent had issued a tender notice number so inviting bids for development of townships at Tellapur and Maheshwaram villages. Under the aforesaid invitation for expression of interest called for by the first respondent participants are expected to express their interest so as to the price that could be paid for the purpose of giving land, and the land can be developed and sold by the bidder. Thus, the development will not be undertaken by the Buddha, but would be undertaken by the private bidders who are successful, and the second respondent would pocket the money paid by the developer toward the price for the land. In ordinary parlance, the same is called real estate business, but the same is in the opinion of the first respondent a project to cater to the needs of the general public, and the first respondent is considering the report by the authority under section 5A. The proposal for finalizing bids by the second respondent was finalized. Notwithstanding the same, the non-speaking order, the first respondent decided to go ahead with the matter and pursuant thereto notification of section 6 was issued. As regards the development of the land, it can be by Buddha itself, or it can engage any contractor by inviting bids. There is no illegality or whatsoever that can be, my lords, relied on so as to challenge the acquisition under the subject to notification. My lord, these are the grounds stated as far as the present writ petition. My lord, the documents relied on. Tellapur G block, where from it has come, there is no legal recognition of such a G block.
Yes.
The very purchase itself is illegal. The sale deeds are void per se for lack of mentioning the relevant documents as to, my lords, the flow of title. And what they rely upon, and at page 37, the proceedings of RDO. This is my lord, sir. Conversion. They rely upon this document, my lords. My lords, my instructions are this order of RDO was set aside by the joint collector later. That is referred to, my lords, in another writ petition. WP 12963, that is not listed today, my lord.
Yes.
This proceeding referred here. What is this proceeding at all, my lords? Subject lands, district Ramachandra, Medak district Ramachandrapuram, Mandal, Tellapur village. Request of the president of the Industrial Employees Cooperative Society Limited, Bandlaguda, for grant of permission to appropriate agricultural lands for house sites purpose. Permission accorded. This is dated by 19th March 86.
Yes.
Sir, in the sale deed executed by the very Mr. Narayan Rao representing the society, there is a reference to a layout of 77.
Yes.
And the RDO considers the request at page 38.
Yes.
In the circumstances reported.
Yes.
In the circumstances reported and recommended by the RDO Sangareddy, permission is hereby accorded under section 61 of the Andhra Pradesh Telangana Area Land Revenue Act 1317, firstly, in favor of the President of the Industrial Employees Cooperative House Building Society Limited, Bandlaguda, to appropriate the agricultural lands at measuring acre 52.90. That's where the subject land is acre 92.39 gutas.
Yes.
52.19, as mentioned above, situated at Tellapur village of Ramachandrapuram Mandal for non-agricultural house sites. That's what is referred here is section 61 of the Telangana Land Revenue Act, my lords. What is section 6? I'll read it. Subject to the following conditions. These conditions he has stipulated. The lands are liable for the levy of a special assessment under section so of for the conversion of non-agricultural land assessment as per AP Non-Agricultural Land Assessment Act. The rules made thereunder as amended from time to time, whichever is higher. Now, the conversion is subject to transfer of title as the land in favor of the society. Land in favor of the society. Whereas my instructions are this proceeding of the RDO is set aside by the joint collector. But that in fact was not clearly stated in the counter, my lord. But I'm bringing to lordship's notice of a fact which is called out from the other writ petition. Whereas the counter filed in writ petition 12963. Whereas this writ petition 12963 today that is not there, my lord.
Yes.
Whereas this is filed by again an association, different association.
Yes.
Association claiming to be the purchasers of the plots. In in this, my lords, there is a categorical contention on behalf of the respondent. Kaitila has filed, my lords. But my lords, I have in fact advised them to bring that proceedings. Subject to what they bring, my lords, I will be able to assist your lordships. Proceeding, I'll just read. Subsequently, Joint Collector Medal White Proceedings number E1 1822 of 96, dated 8th October 96, has cancelled the conversion proceedings of the District Revenue Officer, Medak District, dated 19/5/1987, under Section 166B of the AP Telangana Area Land Revenue Act 1370. This is the pleading, my lord, subject to my lord, the proceedings. This proceeding was not filed in this writ petition also, but there is a pleading.
Yes.
My lord, they sought to rely upon explicit page 40. GORT 698, Municipal Administration, dated 21st June 1989.
Yes.
This is one of the grounds they said. They pleaded that once you have withdrawn, you cannot acquire later. That issue is also covered by a judgment, which I have in fact cited and filed also. This proceeding, what it says, my lords, page 40. The Hyderabad Urban Development Authority proposed to acquire an extent of acre 430.29 guntas of private lands at Tellapur village, Medak district for expansion. Ramachandrapuram Green Town. To the above effect, draft notification under section 4 of the Land Acquisition Act was published in Andhra Pradesh 7/7/1984. And draft declaration under section 6 of the Land Acquisition Act on 5/8/1987. As the lands in survey number 324 to 343, 363 and 364 of Tellapur village pertains to Industrial Employees Cooperative House Building Society Limited, they went to the High Court and obtained stay orders. As per the report of the subcommittee, the Board of Hyderabad Urban Development Authority in its meeting held on 27 September 1988 resolved for deletion of the lands pertains to the Industrial Employees Cooperative House Building Society. The Vice Chairman, Hyderabad Urban Development Authority, requested government for deletion of the lands in survey number so and so of Tellapur village. There are 2 minds. After examining the matter in detail, government hereby accept the proposal of Hyderabad Urban Development Authority for deletion of lands in survey number so and so belonging to Industrial Employees Cooperative House Building Society, subject to the following conditions, for which the society has sent their consent in the letter, second read above. The entire area, that the land including that of the society, should be laid out as one unit, so that the intended development plan of PUDA would not alter. The PUDA will prepare the combined layout in consultation with the society and then release the layout to the portion of land held by the society to the latter, so that the residential plots, etc., could be allotted to the members of the society as per the bylaws of the society and by the society. The collector Medak district is requested to send the withdrawal notification for denotifying the land in question as ordered in paragraph above. My last, this withdrawal is subject to these conditions. What is the bylaw?
Yes.
This doesn't come in the way of the government, my lords, at a later point of time to issue proceedings afresh.
Yes.
Nothing can be placed, no reliance can be placed by the petitioners under this document.
Yes.
My lord, the next proceeding, exhibit T5, this is my lord's an appeal. 6th March 1998, disposed of by the RDO Sangareddy. This also was sought to be relied upon. My lords, para 46, I will be concluding my lords, is sufficient.
Yes.
Page 46. In view of the Mandal Revenue Officer report, Ramachandrapur, the facts explained by the petitioner, it is found that Sri V. Narayan Rao, president of the society at Patanjali, sold away the lands bearing survey number 333, 542, and 363 in favor of Sai Krupa Enterprises Private Limited, Hyderabad. In second time is found illegal. Hence, the patta made in favor of Mr. Sai Krupa Enterprises Private Limited under ROR by the Mandal Revenue Officer Ramachandrapur, while proceedings number so and so hereby set aside. Mandal Revenue Officer Ramachandrapur is requested to keep the record by making necessary corrections in favor of the Society Limited Patanjali. Since these lands are belonging to the plot purchasers purchased in the year 1983-84. How is that the plots can be said to be recognized plots in the absence of the proper purchase by the society and the proper allotment by the society in favor of the industrial employees?
Yes.
This mutation was ordered, but this has not been admittedly implemented in the revenue records. Nothing, no steps have been taken. My lord, sir. The notification, my lords. What the notification normally would contain, my lords, I need not argue on that. The revenue records, whatever, my lords, the revenue record as found by the collector as on the date of 4/1 notification, that is 22nd February 2026. All the names were mentioned.
Yes.
Therefore, my lords, the documents which have been brought into existence at a later point of from 1986 onwards, on which, my lords, the petitioners places reliance, absolutely misconceived. They do not, my lords, confer any right in an immovable property in the absence of a valid transfer of property. There is no reliance of whatsoever can be placed on these proceedings. And the authority, my lords, has proceeded with the revenue record and notified various persons and the extents of the land held by them as on 22/2006 in the revenue records. And my lords, some of the writ petitioners claim in this. Few of them, my lords, who have been notified in this, have filed the writ petitions. Okay, my lords, from bottom, from the bottom 5 above, my lords. Writ petition 6324 of 2007. Likewise, my lords, WP 5118 of 2006. From the bottom, my lord, survey number 366 by double A. From top, my lord, 8 at serial number 8. Sai Krupa Enterprises occupier P. Meghnath Gaur, 2 acre 23. He is the 5th petitioner, my lord, in WP 5118. Sir,
Yes.
page 63. How the objections are being dealt with. That is sufficient, my lords, in the eye of law as regards the public purpose. It's page 63. My lord, this 92 acres is not my lord, separate land, rather in the ring town, contiguous to the other land proposed to be acquired by the Huda and developed. There are page 63. Decision taken under section 5A.
Yes.
Reading from the minutes of the para. In pursuance to the orders of the Honorable High Court,
Yes.
in WP number 19379 of 2006, dated 20th September 2006, Land Acquisition Officer Huda has considered the objections filed by the petitioners and submitted his report to me on 12/9/2006. On the objections filed therein, and on careful consideration of the entire record of the Land Acquisition Officer Huda, I am of the opinion that most of the objections relate to reacquisition of lands which were dropped earlier. Most of the petitioners have purchased the notified land from the Industrial Employees Cooperative House Building Society Limited, Bandaguda. The acquisition is for the public purpose, which includes housing schemes and developmental purpose for general public. As such, there is no bar for acquisition of the plotted area for public purpose. The land acquisition is for public, and policy of the state government is to form townships at various places to cater the needs of general public. As such, the request of the landowners to drop the LA proceedings is not feasible. The petitioners have also sought for payment of compensation on market value, and they have not agreeable to the government rates. The appropriate compensation will be fixed at the time of award inquiry, basing on the relevant sale transaction that took place for 3 years prior to the issue of draft notification of the section 4 of the LA. The petitioners have purchased the lands and their lands not notated in the revenue records. The normal basis for inclusion of their names in notification is revenue records. It is open to all interested landowners to appear at the time of award inquiry and file their claim, sale deeds for payment of compensation. The petitioners also objected the land acquisition, stating that enough government land is available in Tellapur and adjoining villages, and requested to drop the land acquisition. Adjoining government lands also included in the township project. As such, objections are not tenable and rejected. Though a number of same objections are filed, I have perused the report of the Land Acquisition Officer Huda and also the objections under section 5A, and I am of the opinion that they are not tenable and cannot be sustained. Hence rejected for the same reason given in the report of the Land Acquisition Officer Huda. The township project is of immense public importance to cater the needs of the general public, and hence objections filed by the petitioners are rejected. My lord, sir, on 3/2/2007, there's a direct draft declaration as envisaged by section 6 was published.
Yes.
My lord, sir, my respectful submission on the pleadings stated by each of the petitions, not only in this writ petition, in all the writ petitions, so far as the so-called purchasers. Well, there is a cloud, there is no clarity as to the title.
Now your collector says that they are all purchasers of the plots from the society.
Collector may say anything, but what is to be considered in accordance with law?
Yes.
Collector may not, if he acquiesces to anything, does it bind the government, my lord?
Anyway, title dispute cannot be gone in title dispute. You are not claiming any title. You are seeking to acquire these private lands.
Correct, my lord. But who is the person interested
Yes.
to claim compensation?
Yes.
Whether the plot purchasers have a priority, or whether the subsequent purchaser of agricultural land claiming for the same vendor, Sai Gupta Enterprises and others.
Yes.
My lord, we are concerned with the land, whether it was a plot or it was an agricultural land.
Yes.
The court may not consider Unauthorized, my lord, there is not even a layout placed. Whether be it unauthorized or authorized.
So collector did not dispute that. Collector agrees that there are plots. They are the purchasers of plots.
Collector cannot decide the title.
No,
My lords, asking a remark, whether the collector can decide the title, my lords, under.
no, title. I'm not saying title. Whether it is a plotted land or agricultural land.
The claim is they have purchased land from society. There is no dispute.
Yes.
Whether the society has a title or not.
Yes.
Merely because some person do not dispute. It can never mean that the court can simply consider the request.
Yes.
Court is bound to go into the foundational aspect as to the title setup
Yes.
by the society and the so-called purchaser.
Yes.
Apart from the society.
No, what I'm saying is that LAO, who considered the objections raised by the petitioners, based upon whatever documents they have, did not dispute that.
My lord, no, I also don't dispute, my lord, the court also cannot dispute with regard to the purchase. But
Yes.
whether it is a valid purchase or not, your lordship has to decide it.
Yes, that will be decided in case if you want to acquire, while at the time of payment of compensation, that will be looked into.
Correct, my lords. Till such time, whether the titles claim at all can, my lords, give a right for them to challenge the land acquisition proceedings.
Yes.
Who can, my lord, they are challenging section 4(1) proceedings.
No, see,
Before barracks.
I will consider your contention. No, when you are arguing that point, I didn't say anything. Now, whatever objections that are raised by the petitioners are dealt with by the collector, LAO, and then the collector. And they did not say that they don't have title, they don't have locus.
Merely
It is not their case.
The collector did not, my lord, sir, say anything with regard to the validity of such purchase. It cannot mean that, my lord, the aspect cannot be raised before the court.
Yes. Yes.
That aspect.
Yes.
If the collector commits some wrong, can it be said that can be relied on by any person?
Yes.
Neither the government can rely upon nor the private party can rely upon an erroneous approach.
Yes. No, if you say that the collector is erred in saying, accepting all this, and you want to contend otherwise, it's okay.
Collector has simply referred a referral, an observation.
Yes.
Cannot validate the title.
Yes. Yes.
My endeavor is only, my lords, before a person invokes the jurisdiction of the High Court,
Yes.
firstly they should state about their right.
Yes.
What is the right they have exhibited so as to comply the infraction?
Yes.
When they themselves do not have any right.
Yes.
Right to title, right of title over a property.
Yes.
My submission is they cannot challenge section 4(1) proceedings.
Yes.
On the ground that they are the lawful owners of these so-called plots.
Yes.
My lords, what I have argued, submitted to your lordship, the society itself said to allot to the industrial employee. What is the statement made in the affidavit? What is the contention stated in the affidavit? That they have been purchased by
Yes.
an industrial employee for whose benefit the so-called society appears to have been established.
Yes.
How would, my lord, the society acquire the land in absence of valid requisite permissions, exemptions?
Yes.
This is all illegal, say.
Yes.
The court has to consider those things notwithstanding about their dealing with by any statutory authority. Rather, statutory authority cannot decide the complex issues as to the
Yes.
title.
Yes.
My lord, sir,
Yes.
the take your lordship has to have, in fact, a detailed my lord, in 3 volumes, my lord, some notes and also the
single paper.
this is long ago, sir.
Don't last time one
పేపర్ కూడా ఇవ్వలేదు
citations అయి ఉన్నాయండి.
Notes కూడా
ఏమి
photo naya కనిపిస్తుంది.
Yes.
My lord, sir, this volume 2 అని ఉంది చూడండి.
Yes.
My lord. Anyway, we'll provide to them, my lord. This consists of about 10 judgments report by.
Yes.
You could file long ago, madam, but it says we should advise the standing council to furnish us. The written submissions.
Who can record lo leanడి. But not there by on record by them.
No, Your Lordship, this was not argued. This is the first step. Only Adinanath Rao argued before Honorable Justice Nandagar. That's all. They have taken adjournments. That's all. They are not argued earlier.
All right, we'll decide that whether it is served or not. We'll decide later. These are all filed in 2016. Yes.
Anyway, they can take time. A lot will in the meanwhile.
Yes. Yes.
Well, sir, the 10 submissions of the respondents. Going to 7 and batch. That's the non-applicability of section 18. Madam. Lordship got it on page. There are page 3.
Yes. Yes.
Section 18 of the AP Urban Areas Development Act 1975 is not applicable since the land acquisition is being done under the Land Acquisition Act 1894. That is the contention. The petitioners have alleged violation of section 18 of 1975 Act. However, section 18(1) is applicable only if the land is being acquired for the purpose of development or for any other purpose under the 1975 Act. Notification is in present case nowhere stipulates that the acquisition is being done under section 18 of the 1975 Act or for any purpose under the 1975 Act. On the contrary, the notification states that the acquisition is being done under section 4 of the 1895. And the government was of the opinion that the property is needed for the public purpose, that is formation of property. If we read section 18,
One area development.
what areas are
Yes.
So one of the contention that it is hit under 18. How that it is hit a melon, sir?
Yes.
If in the opinion of the government, any land is required for the purpose of development or for any other purpose under this act, the government may acquire such land under the provisions of the Land Acquisition Act 1984.
Yes.
Subsection 2, madam, sir. Where any land has been acquired by the government, they may, after they have taken possession of the land, transfer the land to the authority or any local authority for the purpose for which the land has been acquired, and payment by the authority or the local authority of the compensation awarded under the act, and of the charges incurred by the government in connection with the acquisition. What is wrong in this decision? And in relation to the 4(1),
Yes.
it is subject to notice issued by the collector. Collector is delegated with the powers, and the purpose which is indicated is public purpose, that is township.
Yes.
That is good enough. It need not contain the details, any further details.
Yes.
Rather, the details which were supposed to have been mentioned have not been mentioned by the petitioner. Such a petitioner cannot has say, cannot object at all.
Yes.
My lords, the there are three of these, my lord, on page 3. On the contrary, the notification states that the acquisition is being done under section 4 of the 1894 Act. As the government was of the opinion that the property is needed for public purpose, that is, formation of township. Therefore, the validity of section 4 notification by section 6 declaration has to be evaluated only with reference to 1894 Act, not by reference to the 1975 Act. A division bench of Andhra Pradesh High Court in so and so 2013 to ALD 3 division bench held that the land acquisition proceedings initiated in the land acquisition of 1894 cannot be held to be initiated merely on the ground that it is in contravention of the 1975 Act. Division bench held that once the government satisfies that there is a valid public purpose, the same cannot be held to be initiated on the ground that it is contrary to 1975 Act. That's from here itself I read my lord. The citation has been filed.
Yes, page 16.
Indisputably, the formation of bypass road for which the land in question or sought to be acquired is in the larger interest of the community, and therefore the same should be regarded as a public purpose. Once the government satisfies about the public purpose and initiates proceedings for acquisition of land, the same cannot be held to be initiated merely on the ground that the same is in contravention of the Urban Area Development Act. As regard that judgment, my lord, the matter was carried to the Supreme Court. The SLP was dismissed. That is said in para 7. My lord, the other judgment which has been referred, my lord, sir, State of Punjab versus Sujit in 2007 SPC 292. That is how it is inapplicable has been clearly said. Whereas C, my lord, capital.
Yes.
The petitioners have relied upon Sujit Singh case in support of the argument in section 18 of the 1970 Act has to be complied before the appointment of the 1894 Act. However, ruling in Sujit Singh does not support the said argument. In the said case, the government was acquiring 9,354 acres for setting up of a new town that the Punjab Regional and Town Planning and Development Act 1995. It was mandatory for the board decided by the Chief Minister to approve the site before establishing a new town. The Supreme Court held that since there was non-compliance of the said mandatory provision, land acquisition for setting up of the new town is illegal. The said case is not applicable to the facts of the present case because it is not mandatory for the government to acquire the land under the 1894 Act. Only after procedure prescribed under the 1974 Act as held by the Division Bench in Kalakoti Suvareddy, the government can independently invoke the provisions of the land acquisition Act even without recourse to the 1975 Act. My lords, on public purpose. Landmark case Surara Pratap Reddy, Daulat Singh, Babu Barke, my lord. Public purpose, my lord, sir. As one of the arguments, points is that there is no public purpose. What is public purpose? The section 3F, my lords, of the very Land Acquisition Act is very clear. For townships also clearly, my lords, that also comes under the public purpose. Public purpose. The public purpose has been defined in section 3F of 1894 Act to include provisions of land for town or rural planning. Phrase township falls within the said definition of public purpose. The phrase public purpose would include any purpose for which the general interest of the community, as opposed to a particular interest of the individual, is directly concerned. Public purpose means any purpose which is beneficial to the community or even fraction of the community. The public purpose is wider than the public necessity and is of wide amplitude. And also the three citations, Surara Pratap Reddy, Daulat Singh, they have been compiled in 5 ballots, relevant paragraphs also I just indicate. Paragraphs also indicated. See, Surara Pratap Reddy, 62 to 79, Daulat Singh, para 65.
Yes.
Babu Bhartia, my lord, sir.
constitution bench judgment, para 11. Para F, in the present case, the land is being acquired for a genuine public purpose for constructing township. Construction of township along with outer ring road will lead to orderly urban growth and reduce decongestion, Hyderabad city. Similar construction of township, Malaysian township and Singapore township city, the outskirts of Hyderabad city have been successful and have satisfied the massive housing requirement. It is for the state to decide on the public purpose. The petitioner cannot ascertain lack of public purpose merely because they are also using the land for housing. One of the contentions that we also purchased for the residential purpose. Two judgments, one are 1963 SC 151. There are 57 and 58. Lal versus State of Gujarat 1970. 2 SCC 260. Acquiring land from A and giving it to B is a valid public purpose. If it is in the interest of the general community, even if a fraction of community benefits from the said acquisition, it would be a public purpose. There are three judgments are cited again. I. An acquisition can be struck down for lack of public purpose only if the petitioners are able to demonstrate that the land is being acquired for a particular interest of certain private individuals. This is not the case at all by them, my lords. J. A purpose does not cease to be a public purpose because the state is using a private agency for carrying out development activity. One of the contention that you give it to an outsider for development. That answer, the ratio of these two judgments answer the contention. Okay. It is settled law that the preparation of a prior scheme or the development plan or opinion is not a precondition, precedent for acquisition of land under the Land Acquisition Act. After acquisition, my lords, the plans, everything will be conceived by the development authority. That can't be a ground to impugn the above the policy to acquire the subject land. L, my lords. As long as there is a valid public purpose, state is entitled to acquire land. Any difficulties faced by the state in the adjoining land would not render the land acquisition invalid. M. Without prejudice, the execution of the development agreement in the adjoining land between the Huda and the private developers for construction of almost 6,000 houses, 10% for weaker sections, and the development of infrastructure and urban amenities demonstrates the intention of the state to use the land for building of township. Under the said agreement, title was to be transferred only on developed houses and not on the land. My lords, para N, my lords. The petitions have relied upon the judgment of the Honorable Supreme Court in Bangalore City Cooperative Housing Society, State of Karnataka, 2003 SCC 727, wherein the Supreme Court has held that the acquisition for the purpose of formation of private layouts is not a public purpose as per Section 3F6 of the 1894 Act. The said judgment is distinguishable. The reasons also said by A. In the said case, the Supreme Court was considering the public purpose for the acquisition for a cooperative society. Under Section 3F6 of the 1894 Act, Section 3F6 of the 1894 Act stipulates that for the state to acquire any land for any public purpose mentioned thereunder, there has to be a prior scheme. Therefore, the acquisition was cut down for lack of public purpose and the ground that since there was no prior scheme as contemplated under Section 3F6. There are 67, 68, what they rely upon also is indicated. Unlike above, the acquisition, the present case is for township. Section 3F2 states that the expression public purpose includes the provision of land for town and rural development. There is no requirement for any prior scheme for acquiring a land for development of a township. The above judgment was concerning the public purpose only with respect to Section 3F6 of the 1894 Act. petitioner have relied upon the judgment of the Honorable Supreme Court in so and so region. That judgments are applicable because the ruling, the said rulings deal with the notification of the urgency clause. My lords, page 10 of this compilation, my lords.
Yes.
One of the argument withdrawal of the earlier proceeding. My lord. The answer is, in the present case, the withdrawal of the land acquisition proceedings in 1989 cannot form a bar from initiating fresh land acquisition proceedings in 2006, as there is a genuine need to acquire the land. My lords, the judgment 2014-15 SCC 410 is the answer.
Yes.
My lords, page 11. And the vagueness, my lords, the judgments and the points indicated here is concerning the vagueness.
Yes.
The petitioners are required to plead as to how the purpose specified in section 4 notification is vague and how it affects them from filing 5A objections. There is no pleading on vagueness in any of the three writ petitions. In the absence of pleading, the petitioners are precluded and from attacking the notification as vague. 1973 to SCC 337. She Singh versus Union of India. Even in their 5A objection, the petitioners have not accepted that the purpose specified is vague and they are unable to file an objection on that basis. 2006 4 SCC 683. The specified public purpose township is not vague. It gives sufficient clarity as to what purpose the land is going to be used. If the purpose for which the land is acquired can be ascertained from the zonal plan, it cannot be attacked as being vague. Notified zonal plan specifies the usage of land as residential township. There is no dispute at all with regard to this aspect, my lords. See, when a large land is being acquired, the precise public purpose for each piece of land need not be spelled out. In the present case, it is difficult for the collector to specify with precision as to which portion of the land will be used for roads, parks, schools, houses, and playgrounds. Well, also the judgment cited in this para T. The answer, my lord, as to the objection raised, the various judgments, my lord, are indicated in this. Sufficient to hold that, my lord, that such an objection is feasible. Two pages are there, my lord, with regard to section 6 declaration, page 30.
Yes.
In section 5A proceeding, the petitioners raised the following objections. A to D. The land acquisition proceedings were previously withdrawn. Availability of government land in surrounding area. Objections on title and the names of the petitions have been wrongly mentioned in section 4.1 notification. Objections on compensation. This, my lord, I have already read to your lordship as to how the authority has dealt with. There was no objection about lack of public purpose or vagueness of the public purpose. Objections relating to land acquisition were dealt in section 5A proceeding by a reasoned order passed by the district collector.
All other councils can leave.
Yes. Just waiting for the
Yes,
urgency.
yes. It will take some more time, so other councils can leave. Rest of the matters will come tomorrow.
lord, sir, A to D, my lord, sir, the manner in which the collector has dealt with the objections. E, my lords. 2014 5 SCC, my lord, it is not a bar for initiating fresh proceeding.
Please.
My lord, the next page 14. Ranjan and Nasimarity case was relied upon. My lords, while considering facts of that case, my lords, what was held in the judgment, my lords, there are one, my lords. The third case, section 4 notification used the phrase township and future projects. The single judge held that the phrase future projects is vague. The land single judge did not consider the definition of public purpose 382 in 1894 Act, which defines public purpose to include town planning. The land judge did not consider the principle that it is difficult to define the precise public purpose when large extent of land is being acquired. The land judge did not consider the following judgments of the Supreme Court. My lords, these three judgments of the Supreme Court were not referred. Therefore, the ratio rendered in that manner can be regarded as a per incurie, and they cannot pay upon the ratio laid down in Gajana.
Yes.
My lord, sir. L. Krishnan's case also is referred, my lord, sir. Madhya Pradesh Housing Board versus Mohammed Shafi 1992 SCC 168, they relied upon merits. It is distinguishable because the public purpose specified in 4.1 notification was residential. The Supreme Court held that a different public purpose was specified in section 6 declaration, housing scheme of the housing board in the requisition letter, construction of building and shops under self-financing scheme. These facts may not differ. The ratio laid down in connection with the certain facts of the case cannot be relied upon. 10 minutes at page 15. State of Tamil Nadu versus Mohammed Yusuf 1991 for SCC 224. The holding in this case that there must be a prior scheme was referred to larger bench of 3 judges. State of Tamil Nadu versus L. Krishnan 1996 1 SCC 250 held that the said requirement of pre-existing scheme applies only when the land is acquired under the Tamil Nadu Housing Board Act. Why Munshi Singh versus Union of India, madam? The case is not applicable because the language in section 4.1 notification was planned development of the area. The writ petition specifically was taken though an effective opportunity was available to the appellant. The file objections under section 5A as notification was vague. In the present case, there was neither any such objection in the 5A proceeding nor the pleading in the writ petition. The Supreme Court held that the position would have been different. The master plan showing the land development was available. In the present case, the zonal development plan showing the precise use of the land was notified in 1980. This is the matter of the development area.
Yes.
My lord, sir. These are the, my lord, sir, the broader aspects which I have brought to your lordship. And the, my lord, every paragraph is referred in that, my lord, for your lordship. Consumption, your lordship refers to them, that is suffice. I need not, my lord, consume your lordship's time reading that. If need, my lord, if after they submit anything new, your lordship can kindly consider some liberty to reply. Further, my lord, sir, the basic aspect. But I would also request your lordships to consider the writ petition 12963 of 2008. that is by another society.
Is it listed?
Ameenpur, Hiramguda, Naraguda, and Tellapur village plot purchasers welfare association represented by Murali Krishna.
Not listed now.
It is not listed. Whereas in that counter, the proceedings of the RDO for converting the land was set aside by the collector.
Is the questioning the same notification?
It's concerning the same notification, but what they saw that in that relief is to effect the mutation in the name of the society or the
Yes.
concerning the same notification. They filed the same notification. In that only, my lords, in the counter there is a specific statement by the Tahsildar that the RDO proceedings is, was set aside by the collector. My lords, what is fine.
Wait to see that.
What's your IN number? It's Lakshmarana.
1/2021. No? It's not being, my name is being listed, but number is not listed.
Is it numbered?
It's 1/2021.
1/2021.
It's called. No.
Yeah, 1 of 22.
Yes. Good plan. Yes. They have not filed a reply to this. Let me let you know.
Yes, in allowed. My lords,
That point number 17, the regularization proceedings.
Wait for your turn.
yeah, but my lords, your lordship is.
Yes.
Petition, that's why I have referred to your lord, taken your lordship to the documents. Petition Kalyani Lakshmi Narayan. That's from IA 1 of 2021. What they sought to rely upon is regularization.
Yes.
He stated this also is executed by same gentleman, Mr. D. Narayan Rao. He states in the affidavit he was a government employee. Carnatic classical musician. In my Veena concepts. Obviously, my lord, she was not the industrial employee. For whose sake, my lord, the society appears to have been established. And for the members, the land was intended to be conveyed.
Yes.
So, my lord, again, my lord, was released 27 September 2013. It is subject to various conditions, my lord. This document, the proceedings, my lord, regularizing this. Condition, the Terms and conditions. 4, 5, 6. The regularization of plots does not confer ownership on the applicant or alter the ownership of the land. The regularization order shall not be used as proof of any title on the land. The regularization of plot does not bar the government or any public agency from acquisition of the above land for any public purpose. Last, my lords, it also says further all proceedings and action on enforcement by HMDA initiated or contemplated can be sent for or withdrawn by HMDA. The plan showing the plot regularized is enforced. So this proceeding is 2013. The matter is seized by this court, my lords, sir. This type of approach to HMDA and getting a document like this, my lords, they really
Not for the purpose of title, but to show that there is some layout existing.
Layout has been.
there is, my lords, there is no, my lords, layout at all. Nothing has been, my lords, pleaded at all. What was the layout granted by the Gram Panchayat?
Yes. Yes.
They cannot rely upon the.
You said there are decisions of Supreme Court where it cannot be treated as a real estate business or commercial acquisition is also permissible.
Yes. As far as the acquisition of the land.
Yes.
Yes, madam.
Yes. What are those decisions?
Sudara Pratap Reddy is made that also. Sudara Pratap Reddy case. 1987 SC. 1997 6 SCC 207. Will again compel. 26.
1997.
6 SCC 207. West Bengal Housing Board and other process also. There are 26 to simply because there is an element of profit, it should not make the whole scheme illegal. The private entrepreneur will certainly look to some profit, but to see that the profit motive does not lead to exploitation, even of the rich, and that the houses are available to the poor people and to middle class people at nominal or affordable price, or even on no profit, no loss basis. The housing board exercises the necessary control. It is certainly a public purpose to provide houses to the community, especially to poor people for whom the price are beyond their means, and they would otherwise never be able to acquire a house. 28, there are 28. The court must shake off its myth that the public purpose is served only if the state or housing board or the joint sector company does not earn any profit. There cannot be any better authority than the state or the statutory corporation to supervise or monitor the functions of the joint venture company. Courts will certainly step in if the public purpose is sought to be frustrated. Volume 1 citation. Yes.
Item 6 law counter. 6 law counter. 6 law counter.
That's one of the conditions. That is with regard to the names to be mentioned in section 4 notification, para 12. Para 12 and 13. Para 13 minute I will read. Seen from the above order that the service of notice on a person shown as owner or occupier in the record of rights is sufficient, even though the said person had already sold the land prior to the said notification, unless it is substantiated otherwise that the authorities concerned had knowledge of the rights of interest of any person other than those found recorded as owner or occupier in the revenue records. It is further held that the collector is not obliged to make a rolling inquiries about the ownership of the land. The name of the purchaser is not yet entered in the revenue in the record of rights. Then non-service on such a person does not initiate the acquisition proceeding. Admittedly, the appellant has not got his name entered in the revenue records as owner or occupant of the said land, and therefore he could not complain about non-service of notice on him, nor about the failure to grant a hearing to him. Contention that as per the provision of the Land Revenue Act, there was no application on his part to either inform the revenue authorities about the sale in his favor or to request them to transfer the khata in his name cannot stand, as it has not been brought on record with reference to any pleadings with supporting documents. But in fact, the appellant had made payment for making the necessary entries in the record of rights in the register in his name at the time of registration of the sale in his favor. This upon failure to make entries on the part of the revenue authorities by itself would not cast any obligation the authorities under the act to make a roving inquiry and to try to locate an owner who may have subsequently purchased the lands from the previous owner. Failure on the part of the revenue authority to make entry in the register of notation in favor of the subsequent owner could not render the acquisition proceedings bad in law on account of non-issuance of notice inviting objections to the acquisition proceedings. Service thereof.
Yes.
Sir, submissions and the case law which cited at the bar may not be sufficient to answer the various contentions raised by all the petitioners. And this my lord, one proceeding, if I am able to get from the other. My lord, sir, to be fair, my lord, to your lordship, certain, though I have argued, pleadings are not there from the respondent side, but it is my duty to place before your lordships on certain legal infirmities that always we can submit notwithstanding a pleading.
Yes. Yes.
My lord, I will furnish all the copies.
There's some difficulty, my lord.
Yes, Ramchandra Reddy,
Yes.
in your counter, you have pointed out something last occasion.
The concept that the even prelims as well for the land prime argument that the people have no title. Because to that, the society is not abolished till date. Now it is subsisting and now the TRO is made in charge.
No, not the title, not about the title. About the future development, that adjacent land was developed, given to PPP and to PPP basis, something you said.
The subsidy, the adjacent government land, which is not in dispute, has been allotted to the consortium company.
Where that is stated?
filed in 24697. 4697 of 2008. Or bottom.
Yes.
The lands not regarded on 4 lines.
Yes.
The lands which are proposed to be acquired or adjacent lands already acquired by Pura and the government according to the by the district collector. These lands, apart from that, these lands have been already handed over to the consortium company because at the time of making a bid, they deposited 400 crores to adjust that amount, they have already, allotted that land. The consortium and they have already developed and, they are doing it as a private venture.
One more restriction, see the 100 acres or to my home side, adjacent to this land.
Any pleading?
It is not there, but recent restriction from my client saying that 100 acres.
There are 9 is, their intention has been made clear. Now, when Advocate General is admitting that it can be done, even for commercial purpose. That is only the contention because they have raised in the court, saying that, that the government of Andhra Pradesh and for the matter, even the government of India and other state governments, that where huge funding is required for infrastructure projects, to associate with private sector to invest and develop such projects and such procedure is known as the public-private partnership method. That's what, they said, for mobilizing the finances, it is nothing wrong, acquiring the lands of the people and get the finance.
Yes. Anything?
Executed by Learned Advocate General right from compilations, not be supplied to us.
These are all general contentions only. Citations are there.
As far
Case
as,
law relied upon.
as far as the title of the petitioner is concerned, the society is intact. Now DRO is in charge. Now, no proceedings have been initiated for cancellation of these sale deeds. Now, they say that, that it is against the bylaws. If it is so, the cooperative department, even, in a batch of restrictions in earlier assigned land case, the Honorable Court has observed that, if at all any irregularity is there in, in the allotment of sites, action has been initiated. Till date, no action has been initiated.
Yes, yes. You take this and make copies and anything you want to answer, reply to me.
With great respect to the Learned Advocate General, most of the contexts with regard to title of the land. No way they counter they have stated and they have not mentioned it. There is no whisper, single whisper with regard to that.
First.
So far as my awareness is concerned, they have said that as far as my part is concerned, he is released from the purview of the notification. Then they said that all the proceedings that are initiated are contemplated to be initiated are withdrawn in respect of this plan.
Where?
The last part of it, 17.
LRS proceedings.
LRS proceedings.
Condition number.
Further, all proceedings and action of enforcement by HMDA initiated or contemplated against the said part are withdrawn by HMDA.
That is for on the ground of unauthorized layout, not for acquisition.
1985, what did I went to the outskirts? Average income of 50,000 rupees. Now, influx of the people will be there always into the state. Where do I go now? Instead, I thought after my retirement in 2014, I would go back to Hyderabad and build a house there. I can have an institute also for it, which I'm a professional. Where do I go now? The government keeps on giving this kind of repeated notices, withdrawing again the still notice. I've been waiting for that result years now.
They have allotted under request to my home side. Adjacent to this.
Even when they gave the notification, they were telling HMD efforts and they were 15,000 rupees. Congruent to my life. But they have not filed any counter to my yet.
Sure.